All right. So what up, y'all, man? Welcome to the Police Stop Law class number 1. This is for brothers who are and sisters who are ready to stop getting their asses beat at these police stops. Ready to start fighting back, but with law, not with your mouth or your hands. So, this is the one thing that has not been tried yet. Everybody wanna scream and yell and cry and march and do every other thing but learn the law. So this is the push that I got going right now, because I've been to the promised land. Like the law is, it is. I mean, dude, the law is like the promised land. I keep telling people that, and they don't understand because you've never been there. It's hard to show somebody promised land if you ain't never seen it. But I'm telling you, learning the law, once you learn it and once you know it, then no one can ever take it from you. And it's what runs everything. And you'll start to see the world part ways for you when you know the law. But, you know, unless you put in the time to know that, you're going to always, you know, and I'm not going to say always, but most melanated people will always refute that the law will work because of the history that's involved with policing and the law and melanated people. So, like, if you guys saw the video that I put out, the Kung Fu of law. You know, Kung Fu is learned skill. So anything can be your Kung Fu. You can be Kung Fu. Your Kung Fu could be cooking, or whatever it is can be your Kung Fu. But brothers do not have any type of law Kung Fu. I mean, there's a few people sprinkled here and there that know the law, but even most of the melanated people who think they know the law, they really don't. And then even if they do know it, they're still scared to assert it to a certain level. Like you'll see a lot of there's videos where you'll see you know, certain lawyers and people who do know the law, they don't, you know, when they get caught up by police, the police will still intimidate them just because, you know, they're you know, that gun is some intimidating shit. That gun on the hip, and you know, and that PR-24, what they call it, you call it Billy Club, but that shit hurts. That shit hurt when you get hit with one of them motherfuckers. So you know, the fear is there, and so you'll get a lot of melanated lawyers who will assert the law, but only to a certain point. They won't be aggressive with it. The whole point of learning the law, though, is it takes your confidence in order to assert it. Like if you're not confident in the law, it doesn't matter. It's not gonna work for you. So even if you do know it, because a police officer will test you, they lie with confidence because they're taught to have confidence and assertiveness in police school, you know, in those police academies. So that's embedded in them. They can't even leave certain classes till they pass aggression tests and things of that nature to make sure that they're able to assert the law when they're out there, so they don't get killed. You know, you can't walk up on somebody who's suspected of a robbery with a voice like, y'all need to stop. Y'all need to put your hands up now. You can't do that. Nigga, like, get your bitch ass out of here. So, you know, you got to be real assertive, and as you can see that when you see women police officers who are very small, they'll still talk with an assertive voice. A lot of that is because they have the gun with them, so they feel that the gun gives them a little security. But they're taught that it's a lesson, it's a concept and mode that they're taught, and it's a concept that you need to use when you're out there with the police, but you don't use it unless you know the law. And that's the most important thing. See, most people, or most melanated people, and I'll say in to a large degree, a lot of people, they look at TV and then they start spouting the laws that they learn on TV, which are completely false. This is most of the laws that you will see on TV have nothing to do. Damn it, have nothing to do. Sorry, I messed up this list. All right, so most of those videos or those TV shows don't have. I mean, they're based in the law. Some of them, they'll have a good law base, but they don't go in depth into the law and show you the nuances or put it in context. So a lot of people you'll see these videos, and we're going to watch some videos, some older videos with Philando Castile and Eric Garner and Sandra Bland, because we're gonna see what happened at that police stop, where it went wrong, because in each one of those situations there was a point to where those victims could have stopped what happened, and they just didn't recognize or know the law enough to be able to recognize that situation. So before we get into this, make sure y'all know I am not a lawyer. I don't claim to be, nor do I want to claim to be a lawyer. So this is not legal advice. This is just education for educational purposes. However, I have studied the law for 20 years. So everything that I tell you, you go look up on your own. Don't believe a damn thing that I tell you. Not one word. You go look it all up. Now, one of the first things to know before we get into the videos is when you're out there and you're getting stopped by police, don't ever pretend to know the law, or if you or be confident in a law that you haven't actually looked up. Meaning, if somebody told you this or you saw it on TV, or you don't ever want to be confident in asserting that law, because it can be completely wrong, and most of the times it will be. But when you do know the law, it is extremely important, going back to being assertive and aggressive, that you assert that properly with the proper amount, not aggression, but just confidence. See, there's a difference when you're at these police stops and you get aggressive, because they're peace officers and they're taught to squash aggression to bring the peace. So they're looking for the smallest bit of aggression, so they can jump into action and do what they do. Oh, shut! Oh, what's wrong with you? Why are you acting like that? Why are you getting an attitude? See, they'll ask you why you're getting attitude with an attitude, in order to put you in a bad mood, so that you get a bigger attitude with them. So it's a tactic. They try to incite you so they can prolong the stop and fish for more crime, or evidence of crime if you have it. Most of the time, which they'll make up. So it's very important, though, that you do not assert the law if you don't know it. If you just heard it, if it's something that you think you heard. Like, I'll give you an example where most people will say, you can't pull me out of the car. You don't got the right to pull me out of the car. That's an absolute falsehood. A police officer has absolutely every right to pull you out of the car. But you don't know that. You've seen it on so many videos and sovereign videos and stuff like that, that most people think that's a real thing. It is not a real thing, because the sovereign people talking about it, they sound articulate, some of them, and like they know what they're talking about, but it's not true. So that's what I mean by that. And so we're gonna watch, like, let me see if I can share the screen. Y'all see the screen?
Yep.
Yes.
Yeah. Yeah. All right. So the first one we're gonna watch here is the Sandra Bland video. Hold on, let me. Where is it? Where's the Sandra Bland video? So let me just type it in here. I know everybody's seen that video, right?
Yeah, I just watched it again the other day.
Man, and that's a sad video right there. There was no brothers around to help her.
Would they have anyway?
I believe so, actually. I believe some brothers there, they definitely wouldn't get as aggressive. Okay, so we're about to watch this video, so we're about to go over the things that she did and did not do that were either right or wrong, and as well as the police officer. So we're gonna watch a few of these videos today with police interaction, so that, because we can talk about the law all day, but it's more about the experience and you getting familiar with the lingo and the interactions with police officers. So that you don't have to go out and keep getting arrested or pulled over to do that. There's a lot of videos of people what's called auditing the police. And so they'll go out there, these people who know constitutional law, they'll go out there and, you know, not even commit a crime, but just do some regular, you know, legally sanctioned or something where their rights are constitutionally protected, and see if the police officers will try to bug them. And then they'll flex their rights on the police officers, saying if they know or not. So there's a lot of videos on that. So because of that, you don't have to go out there and get into, and like when I was getting into the law, you had to go out there and get into these damn situations yourself and learn firsthand. You get your ass smacked up. I was in a few of those. I didn't get spotted. Yeah, I got the cops pulled me over, had their knee in my neck on one situation and the gun in my head. But other than that, the rest of them weren't violent. Oh, except for the one at UCLA where they arrested me, my girl, and my homie. But it didn't get too violent. It was just a gang of cops that showed up. But so here we go. We're about to watch this Sandra Bland, and before we get into the law, I'm going to ask you guys, where do you see where it went wrong? Oh, actually, hold on. So if you're on here, mute your phone while the videos are playing. You too, Mel.
Is there supposed to be sound?
What?
Is there supposed to be sound on this?
Yeah,
because if so, there's nothing coming out.
What?
Nope. I just see the video, but I don't hear anything.
How do you not hear anything? I'm watching. Is that for everybody else? None of y'all can hear anything too?
Correct. I can't hear as well.
What's up?
Okay.
Y'all can hear now?
Yeah.
Will it take time to patrol? The reason for your stop is you failed to signal the lane change. You got your driver's license insurance with you? Give me a few minutes, all right? You okay?
I'm waiting on you. This is your job. I'm waiting on you. What do you want me to do?
You seem very irritated.
I am. I really am. Crap for what I'm getting the ticket for. I was getting out of your way. You were speeding up, tailing me. So I moved over and you stopped me. So yeah, I am a little irritated, but that doesn't stop you from giving me the ticket. So.
Are you done?
You asked me what's wrong, and I told you.
Okay.
So now I'm done. Yeah.
Okay. You mind putting out your cigarette, please? If you don't mind.
I'm in my car. Why do I have to put out my cigarette?
Well, you can step on out now.
I don't have to step out of my car.
Step out of the car. Step out of the car.
No, you don't have the right.
Step out of the car.
You do not have the right to do that.
I do have the right. Now step out or I will remove you.
I refuse to talk to you other than to identify myself.
Step out or I will remove
I
you.
am getting removed for a failure.
Step out or I will remove you. I'm giving you a lawful order. Get out of the car now or I'm going to remove you.
And I'm calling my
I'm going to yank you out of here.
Okay, you're going to yank me out of my car?
Get out.
Okay. All right.
25.
Let's do this.
Yeah, we're going to.
Yeah. Don't touch me.
Get out of the car.
Don't touch me. I'm not under arrest. You don't have the right to take me.
You are under arrest.
I'm under arrest for what?
25.
For what?
7 County FM 1098.
For what?
290. Send me another unit. Get out of the car.
Another unit, FM 1098.
Get out of the car now.
Why am I being apprehended? You trying to give me a ticket?
I said get out of the car.
Why am I being apprehended? You
I'm
just
giving
opened
you a
my car
lawful order.
door. You just
I'm
opened
going to
my
drag
car
you
door.
out of here.
So you threatening to drag me out of my own car.
Get out of the car.
And then you
I will
stop
light
me?
you up. Get out
Wow.
now.
Wow.
Get out of the
Really,
car.
for a failure to signal. You doing all of this for a
Get
failure?
over there.
Right, yeah. Yeah, let's take this to court. Let's do
Go ahead.
for a failure to signal. Yep, for a failure to signal.
Get off the
On
phone.
my school.
Get off the
I'm
phone.
not on the phone. I have a right
Put
to
your
record.
phone
This is
down.
my property. This
Put
is
your
my
phone
property.
down.
Sir?
Put your phone down right now. Put your phone down.
For a failure to signal, my goodness.
Come over here.
Y'all are interested.
Come over here now.
You feeling good about
Stand right here.
You feeling good about yourself?
Stand right
For
there.
a failure to signal, you feel real good
Turn
about
around.
yourself, don't you?
Turn around.
You feel good about yourself.
Turn
don't you?
around now.
What are you?
Put your hands
Why
behind
am
your
I
back and
being
turn around.
arrested?
Turn around.
Why can you tell me?
I'm giving you a lawful order. I will
Why
tell
am I
you.
being arrested?
Turn
Why
around.
won't you tell me that part?
I'm giving you a lawful order. Turn around.
Why will you not tell me
You are
what's
not
going on?
compliant.
I'm not complying because you just pulled me out of my car.
Turn around.
Are you kidding me? This is some bull. You
Hands
know
behind
it
your
is.
back.
Because you know this is straight bull. You full of straight. That's how y'all are. Some scary cops. South Carolina got y'all scared. That's all it is. Scared of a female.
If you
All right. So you don't know what happened. He starts manhandling her, and the woman cop comes over to handle the situation after that. But for some reason, I think he was twisting her arm or something, so she started screaming. But it's just more of that. So right off the bat, what was done wrong in somebody else's opinion? Just even if you think you're guessing.
On whose part, the officer or Sandra's?
Huh?
What was done wrong on the officer's part or Sandra's?
Whatever. What was the very first thing that you saw done wrong?
I found it strange that he asked her to put her cigarette out.
Okay. Anybody else?
I thought it was strange that he went over to the passenger side instead of the driver's side.
No, that's for safety.
He didn't get out of the car. I mean, she didn't get out of the car when he requested.
Well, right. Well, let me go back to you on the cigarette thing. Did he have the right to do that or no?
No.
Okay.
Yes.
Wait, I'm not gonna answer. All right, Shep. Now, what were you saying?
She didn't get out of the car when he requested it.
Right. But that wasn't the first thing that was done wrong. That was in the line in the series of things that she'd done wrong.
Actually, it's going back to the cigarette thing. So no, that actually wasn't it. It was the very first thing that she done. This is a chopped up video. The actual video is about a good 10 minutes, good 10, 12 minutes, something like that. So what you don't see is the officer's demeanor at first, beforehand. So the officer, when he pulled her over because she didn't signal. She changed lanes without signal. Now, was he stalking her? Was he, probably, yes, absolutely. Because he had just pulled somebody over, and then he came from pulling that dude over and started following her, was waiting for her to do something. So she tried to get out of the way without signaling. Boom, he pulls her over. Now, when he pulled her over, he wasn't belligerent at all. He was pretty good demeanor. How you doing? So as you can see, like when he was asking her about when he was on the side of the car, he wasn't aggressive. He wasn't aggressive with her. He was just basically following his procedure. So then what happened? What did you see? What did you guys see from that point?
She was upset
Mm-hmm.
that she got pulled over.
Mm-hmm.
And she even made mention of that, and that's when things started to escalate a bit.
Right. So her very first thing was letting the police officer or letting the situation get her upset enough to where she wasn't in control of her emotions. So when the police officer comes over there, now is it illegal for you to talk shit to a police officer? Absolutely not. It is absolutely not illegal for you to talk shit to a police officer unless you're threatening a police officer. Is it wise for you to talk shit to a police officer? Probably not if you don't have backup. It's probably not wise to do that if you don't have backup. Now she was in a state. These are some circumstances. She didn't even live in the state. She was going to the state for a job interview. So she didn't even know the laws of the state.
Mm.
So even if she was correct about everything she was saying, that would only be for law that she knows in her state. Police laws aren't the same necessarily from state to state. So when she got belligerent, she got upset right off the bat. Again, like I just told you, police officers, when I'm talking here, I'm mute your phone. Everybody mute your phones on. I had that stuff in the background. People will be watching. So right off the bat, he kicks into superhero officer mode. Oh, I gotta calm the situation. So that's why so then he goes with can you put your cigarette out? Does he have the right to tell her to put the cigarette out?
Well, watching some of your other videos, you spoke on how the Supreme Court gives officers the right to do anything, basically, during a traffic stop. So he can really tell you to do whatever, right? Unquestioned authority or whatever. So
exactly. See, these are laws that you need to know when you're fighting with a police officer at a traffic stop. When they stop you, when a police officer stops you, they may not have the reasonable suspicion to stop you. It could have been absolutely bogus, the reason they stopped you. However, that doesn't necessarily give you the right or it does give you have the right, but it doesn't give you the green light to go ahead and start acting crazy unless you are well aware of your laws and you're going to assert those laws in an assertive but calm manner. That's what you have to do. You can't be getting belligerent with these dudes because, again, the Supreme Court has given them unquestioned command. So when they pull you over, they can immediately tell you to get out of the car while they complete the stop. If they leave you in the car, that's just because they've allowed you to stay in the car. So when he was doing that all with her, you can tell, you can see the video chopped up. He got her information. He goes back to the car. He comes back. He said, you know, you all right? He's like, yeah, I'm all right. Woo woo. She said, you know, you asking me for my thing. Whoa, whoa. You know, and then she goes off on that. He says, okay. So that kind of pissed him off a little bit. And he said, okay, well, can you put your cigarette out? He probably wouldn't have asked her to put the cigarette out if she hadn't started talking shit. But then when she says, why do I got to put the cigarette out in my car? See, that was her not knowing the law. Now, she was right. He was being a punk ass bitch for he was being, you know, he was getting butthurt because she started getting an attitude with him. And that's why he did it. And she was absolutely right that he was morally wrong for what he was doing, but he wasn't legally wrong. And this is where melanated people don't make the distinction. Yeah, you may be morally right. So there's two things in law. It's called being right and correct. And in law, those two things have to add up or they don't work. And when you walk into court, what that means is you can be philosophically right about your argument. Absolutely. But you have to be correct in the law. Does it line up? Is there any law written on that backs you up? And if those two things don't add up, then you don't have a case in court. That's why it's called being right and correct. Yeah, you're right. Philosophically and morally, yeah, you're right. This shouldn't have happened. But is there a law to back you up on that? And if there isn't, you can't be like, oh yeah, you can't do this, you can't do that, you can't do this, just because you feel that it's morally wrong. So going back to this case, you know, it is of the utmost importance that you remain calm at a police stop, because all you're doing is giving them ammunition. That's what they're looking for. They ain't looking. Remember, these people have quotas, and so they're giving you tickets, but they also, you know what I'm saying, they also get when they for arrest and stuff like that, that gets put on their record. How you think they get promotions? It's how many arrests did you do? You know, how many convictions and all this and that off your arrest. All of that stuff adds up for them to get promotions. So when they pull you over just for a ticket, they ain't just trying to give you a ticket. They're trying to look for something bigger. So that goes in their record that they, you know, they did this, they did that. Oh, look at who I took down. Or I took this person down. Or I got this many arrests. Or whatever it is, it boosts in their record. That helps them get promotions, which is money. So every time you get a promotion to sergeant or whatever it is, detective, you get a boost in pay. So this is about cheese. when they're doing all this to you. You don't know that. You think a lot of the time they're being assholes, which they are, but a lot of the time their money is tied to how many convictions or arrests that they get. And as well, how many citations but that's just a quota. That's something they have to do, is issue a certain amount of tickets every month, or they get written up by it. So, you know what I'm saying? These are things that we don't know, that this is common information that it's out there. They don't hide this information, but it's something that we don't go look up, and information that we don't have when we engage in these traffic stops. So that was the thing with her. And if she just remained calm, literally just remained, even after she, you know, he asked her, why you have an attitude, even though she got her little joint off, which was cool. She got that off. And then he said, all right, well, can you put your cigarette out? Had she just put the cigarette out and not been tripping, she would have still been alive. Had she just done that. But we don't understand how to not keep escalating the situation, because we feel, oh, well, we've been smashed so damn much that we just get fed up. But that's the time when you have to remain the calmest. Because they know that you fed up. They know that you at the tip top with this bullshit, and they ready to push you over the top so they can do they can do what they do. So let's go to the next video.
Would it be fair to say that she didn't exercise her right to remain silent as well? That could have helped.
Well, we're gonna get into that in a minute.
Okay.
We're just going over certain videos at the moment. The next one is Eric Garner.
It has happened again. Just 9 days after the uproar in Ferguson, a grand jury in New York City has refused to indict yet another white police officer said to have killed an unarmed black man. The incident, which involved an apparent chokehold, was captured on video and went viral. And tonight, protesters are in the streets. The president is weighing in, and ABC's Ron Claiborne is on the story.
Angry crowds tonight in the streets of New York, protesting yet.
Let me see. Let me try to get the actual video. This is where's the video. Man, where's the actual video? I thought this was it. So they keep starting. They don't start the video from the beginning. That's actually the most important part, is to see the video from the beginning. Let me see if this one does it.
Good evening. For the second time in as many weeks, a grand jury has found showing a man named Eric. Involves the video seen around the world by now, showing a man named Eric Garner being taken down by mostly plainclothes police officers while being placed under arrest. One of the officers employed a chokehold. Moments later, while on the ground after complaining he couldn't breathe, he was dead. Well, tonight, while so far peaceful, there are protesters in the street.
Now, I can't find the actual video, but right from the beginning part is the most important part actually about that video. Let's see if I can, this is.
A routine arrest goes horribly wrong, and a man seems to die at the hands of the police. The apparent chokehold caught on tape now reverberating across the country, and the issues fraught with race and public safety. Here's ABC's Ron Claiborne.
Damn, they keep doing the story on the damn video instead of actually getting the video. So from what we just saw before though, so when you saw the cops walk up on him, Eric Garner was acting like the police they were messing with him for no reason. Now, he, again, right and correct. He probably was right. He was most likely right that they were just fucking with him because he was a brother. However, they were not legally wrong, because he had been caught at that spot. He had been caught at that spot selling cigarettes, little singles or whatever, which is, misdemeanor or whatever. And so because he was arrested in that spot before committing a crime, that gave police reasonable suspicion that he was committing the same crime. And so that allowed them to walk up and engage with him. Because he didn't know the law, he didn't understand that. All he had to do when they walked up to him was just tell him his name and let them pat him down. That's it, because he wasn't doing anything. They couldn't see him doing anything, committing a crime. All they did was suspect him of committing a crime. And we're gonna get into reasonable suspicion in a minute. But with that, all they were able to do was ask him his name and pat him down for weapons. And had he just remained calm and done that, because he actually wasn't selling cigarettes that day. Like, that was the day he actually wasn't selling cigarettes. That's why he was pissed. Like, why y'all fucking with me? I'm not even out here selling cigarettes. And so it escalated into, the situation in which you saw. But the reason that the police didn't get convicted was because the initial engagement was legal, was lawful, because because of under reasonable suspicion. So because I can't find that whole video, we'll just go to let's keep saying no indictment. All right, so I'm not going to try to find, because all of these are just news reports on it. So I'm just going to go back to.
Got a question.
Uh-huh.
So they didn't get in trouble for that incident because legally they had a right to do that, even though they put on an illegal chokehold.
Well, they didn't. So when you watch, that's all right. If we can, I want to watch the video. So if you watch the video again all the way through, let me see. Well, let's watch the chokehold part. I'll explain.
Put your hand behind your back.
So now you see that?
That was how 43-year-old New Yorker Eric Garner died.
So what you just saw right there was the reason they didn't convict him was because the chokehold didn't kill him. The chokehold was just a takedown, and they didn't. And because he was so big, they allowed. Remember, police officers have great leeway when they're arresting you, in order to be able to, especially when they feel that their lives are in danger or whatever it is, or they're a threat to bodily injury. The Supreme Court gave them great leeway to be able to do whatever they do to effectuate an arrest or at least a detainment to secure the situation. So when they took Eric Garner down, he only took him down with the chokehold. He wasn't choking him when he was on the ground. What had happened was, because Eric Garner is so big, he doesn't breathe well. And so when they took him down, when he first applied the chokehold, it cut off his oxygen. Make sure you mute your phone.
Are you serious?
So when they took him down with the chokehold, that initially cut off his air, right? So when they got him down, when you watch the video again, you see when they pretty much fell to the ground, the dude released the chokehold. So that didn't kill him. What had happened though, his air had been his air was already gone. Remember, now you're moving around too. He's like 300 pounds. So he's moving around. You eat up a lot of oxygen in your body, especially when you're that big. And if you don't have that much, you don't have good air. So when the chokehold took him down, it cut off his air. Then this is what killed him. This is mostly what killed him. What you see right now is the dude doing that. See how he's pressing his head to the ground? By that time, so now what's happening is his body is pressed against the concrete. He doesn't have any air. Remember, the air had already been, he had choked. They had cut off most of the air from when they were trying to take him down. When he fell on the ground, they laid on top of him, which compressed more air out of him. And so what you see right now is now he's pushing his head down, which is compressing more air out of him. So it was all of these things together that they ruled that caused his death. It wasn't a chokehold. It was because he was big, he had like apnea, and he was short of breath when they took him down. All of those things had contributed to that. That's why it wasn't just a chokehold. And the reason they didn't do anything is because they ruled that had he complied when they first walked up with the lawful order, none of this would have happened. So that's why, see, just a situation, just something as simple as this, because he wasn't even doing anything wrong that day. He was just tired of them messing with him. And I know it gets frustrating, but you have to remain calm with these dudes, because they'll go back to, they'll go back to their communities and they'll use taking you down as, a badge of honor. I took down that big black motherfucker yesterday, man. Did you see me take him down? They talk like that. they actually talk like that. So you can't give them any ground. They're looking for it. So we're gonna get in. After we finish watching the videos, we're gonna get into the law of it. But you know what I'm saying? When you know the law, or when you know the law or your rights, when you're able to assert your rights, you don't have to be scared of these cats, because they're only allowed to do a certain amount of things. But you don't know that. If you don't know that, this is when they go off the railway. We're gonna watch a couple more videos that show you how people don't know the law, how they just let them do whatever the hell they want. But that's what happened with Eric Garner. Now we're gonna watch the Philando Castile video. Now this is a little trickier.
Dash cam video of the philanderer.
So pay very close attention. I want you. This is one video that you really need to pay close attention to see what's going on right here, and see who, if anyone, was in the wrong and what went wrong.
Well, sir. Good. How are you? Good. Reason I put you over, your brake lights are out. So you only have one active brake light, and that's going to be your passenger side one. Your third brake light, which is up here on top, and then this one back here, is going to be out. You ever like some shirts? I have to tell you, I do have a firearm.
Was that a legal stop?
Yes.
He was? Did he have, how many brake lights did he have out?
One.
So he still had his, both actual brake lights were working. So now it may depend on your state, but in most states, you don't need 3 brake lights. 2 brake lights is enough. You know, your third brake light in your windshield, not your windshield, but your back window, that doesn't need to work. That's an extra, that's a what they call a security light. That's an extra light for security. It's only the 2 back lights that need to be working. And so when he stopped him, he lied. Or if he, now again, in Michigan, that could be a law, but in most states, that's not a law. That your third brake light has to be on. Because that means all cars have to have 3 brake lights. If that had to be a law. But both of his brake lights were working. 2 brake lights were working, that was good enough. So that's the initial thing. The initial stop could have been bullshit. Again, the law in Michigan may be different, where you have to have, if you have 3 brake lights, all 3 of them have to be working. But in all my years of studying law, as far as that, only 2 brake lights have to work.
I don't reach for. I have to tell you, I do have a.
Oh wait, let me go back.
Brake light with. Well, sir. Good. How are you? Good. Reason I put you over, your brake lights are out. So you only have one active brake light, and that's going to be your passenger side one. Your third brake light, which is up here on top, and then this one back here, is going to be out. You ever like some shirts?
So wait a minute, which one did he say was out? Which brake light did he say was out?
If I'm not mistaken, the driver's side, the passenger side works, but he says the driver's side was out, which is incorrect. The driver's side was dimmer than the passenger side, and there was no third one.
All right, so let's go back real quick.
I thought he said it was too loud.
I thought he said the middle one and the driver's side is out. Both.
So we can see 2 brake lights on, right?
Right. You can clearly see 2 brake lights.
You can see 2 brake lights on. The one in the window is not working. The one in the window is not working.
No.
Well, sir. Good. How are you? Good. Reason I put you over, your brake lights are out. So you only have one active brake light, and that's going to be your passenger side one. Your third brake light, which is up here on top, and then this one back here, is going to be out.
It's not out.
You have license insurance?
So he told him 2 brake lights was out when only 1 was out. See, that was some bullshit.
Hey, Kev.
Uh-huh.
Then you say that police officers can legally lie?
Yeah.
Mm-hmm.
But they can't lie about that. They can't lie. They can lie to you about certain laws, but they can't lie. They can't lie to you about this is called color of law. This is against the law for them to make up law. They can't make up law and charge you with law.
Right.
So that's against the law. That's called color of law. And color of law means so color in law means the semblance without the substance. I mean, it looks like it, but it's not. So when cops can come up and tell you a law that seems like it's the law. When they do that, they can say something very similar to the law. When it's not the law, it's called color of law, and it's illegal. That's actually illegal for them to do that. There's statutes and laws against them for doing that, lying about the law. They can lie to you about other shit, but they can't lie to you about the law, about what's what, because then you can charge them with color of law. So this thing right here, him telling them he stopped him because his brake light went out. Now again, that's not against the law. What would happen if he just went to court and he got the dash cam video? The dash cam would show that his brake light was on, and he would just win the case in court. That's all. But from this position, he didn't stop him. He used that as an excuse to stop him. It was a false excuse why he used to stop him. So let me go back. This is very important. I want y'all to see from the interaction, from the very first interaction.
Well, sir. Good. How are you? Reason I put George, your brake lights are out. So you only have one active brake light, and that's going to be your passenger side one. Your third brake light, which is up here on top, and then this one back here, is going to be out. You have license insurance? I have to tell you, I do have a firearm on me. Don't reach for it, then. Don't pull it out. Don't pull it out. Don't pull it out. Don't move. Oh, man. Don't move. Don't move. Oh my God, I'm shaking. Don't move. Don't move, baby. Code 3. Get the baby out of here. Don't move. Baby, please. Whatever you do. Get 21. Get up. Back there, code 3. Shots fired. Back, code 3. We got pulled over for a busted tail right in the back. And the police, he's tired. They took my license. He's carried the license to carry. He was trying to get out his ID and his phone.
Now his girl is on Facebook Live streaming while that's what you hear right now. I'm sure y'all seen that video. Now, what was done wrong? First of all, was there anybody in the wrong? And if so, who was in the wrong and what was done wrong? Not
Castillo.
You. Not you.
Oh.
When he told him that he had the concealed actually he told him he had a gun. Mm-hmm. He was reaching for his concealed carry license, and the officer thought he was reaching for the gun because he said he had a gun.
Right. So who was in the wrong? Or if someone was in the wrong, who was in the wrong, or was anyone in the wrong in this situation?
I wouldn't say he was in the wrong, but it was a bad communication between, I guess you can say, the victim.
Is he right, y'all? Y'all agree or disagree?
I would say the officer was in the wrong. I would say the officer should have instructed him to tell him where the firearm was located. so he would know if he was reaching for the firearm or his license and insurance, like he previously instructed him to reach for.
Right. That's a good statement or a good assessment. Anybody else?
Hold on. I thought wasn't the girl driving?
No. Lando was driving. She was.
Oh, he was driving. Okay. All right.
Anybody else? Y'all agree? Was the officer wrong for not asking where the firearm was?
Still want me to be quiet, or?
Yeah, you've been in this already.
Okay, I'm going on mute there.
You got the cheat code.
I wouldn't have said anything about a gun.
Huh?
Yeah, I wouldn't have either. I wouldn't have said shit.
I would let them find the gun. You know what I'm saying?
No, you can't do that. You go to jail if you don't do that. You have to, if you have a firearm in the car, you have to alert the police officer about the firearm. If not, you're going to jail for a long time. If they find a firearm and you don't tell the police officer that you got a firearm in the car, you can go to jail for a long ass time.
But they most of the time, whenever they stop me, they ask me if there are any weapons in the car.
Right.
I don't volunteer the information. They ask
right.
me.
Exactly.
Yeah. And I say no. So the officer was wrong because that's his protocol in the stop. To ask if you have any firearm.
But that's not necessarily his protocol. That's his protocol if they're trying to prolong the stop to try to find something else. If they usually, sometimes they will ask you if you got a weapon in the car. If it's just a regular routine traffic stop, a lot of times they won't ask you that, especially if the officer feels that you're not a threat. If the officer feels that you're not a threat, he walks up. He has a woman and his kid in the car, so the officer probably didn't think that he was a threat like that, enough to ask him if he had weapons in the car. They usually do that when they got big niggas in the car, or something like that, when they feel that nigga may have a gun.
Yeah, I mean, but I just think, man, if he says don't reach, then it'd be really like, if I'm just thinking in the mind of an officer.
Mm-hmm.
But if I say don't reach and you see somebody reaching, that would make me pretty nervous.
Right.
It's not saying I would shoot somebody, but goddamn, that would make me nervous.
Well, you're usually see, and that was the other thing. They're training. They bring some radical training dudes, some ex-police officer to teach these dudes that you want to shoot first and then ask questions later. Like, and so they showed one of his seminars, and this dude went to one of them seminars. He was taught by this guy. And he said, "Do you want to go home, or you want to be the one to go home, or you want them to go home, and then ask questions later?" So that's how these are the seminars that the police force send these officers to learn how to handle a police stop. But it's the completely wrong way to do it. Now, even though homeboy was taught that, the police officer was taught that, in this situation, no one was in the wrong. Who said that about the bad communication? You were right. That was the bad communication, because of basically what happened is the guy or the police officer walks up, and most people think the police officer was some evil, belligerent dude. You can see from the interaction that he wasn't even upset. Like, because the Philando was like, he asked him, the cop said, "How you doing?" He said, "How you doing?" And he's like, "I'm good." And then Philando said, "How you doing?" He said, "Oh, I'm good." Like, he's like, "Thanks." He's like, thanks for asking. So he was kind of he was in a cool mood. So when he says, and this is where it's so important for you to listen to the officer and comply with their orders. Don't comply and listen very carefully, because the police officer said, "Yo, can you give me your driver's license, your license and registration?" He says, "Okay, that's one order. Give me your license and registration." He handed him the license. He already had the license. He's going for the registration. In the middle of him getting the registration, before he reaches for the registration, he tells the police officer, "I have a weapon in the car." The police officer says, "Oh, okay, well, don't reach for it." So he says, "Oh, okay." Philando says, "All right, I'm not reaching for it." But now Philando is still complying with the first order of get your registration. So the police officer is like, all he hears now, he'd have forgot the first order of give me your registration. Police officers are taught when you found that there's a weapon on the scene, you have to secure the weapon. That's an actual term. You have to secure the weapon in order so because then if there's a weapon that's unsecure, anybody's liable to get shot just by accident. So when he tells the police officer about the weapon, the police officer's mind is on the weapon now. It's on the gun. He done forgot about the registration. So Philando didn't know. He's still reaching for his registration. Police officer's like, don't reach for the gun. All he remembers is you just told him you got a gun in the car. So he goes, don't reach for it. I'm not. But he's saying I'm not, but still reaching for something at the same time because he's reaching for registration. But he's saying I'm not reaching for the gun, but you still moving and reaching for something, which the police officer doesn't remember that he told you to get the registration. And so that's what happened. When he reached for it, it was literally just terrible communication, a miscommunication. And that's why the police officer didn't get charged. Excuse me. That's why the police officer didn't get charged. This was a horrible, horrible situation, but not one of belligerence or malevolence on the police officer's side. It was literally just some bad communication between both of them. And so this is a teaching tool for you to understand. First of all, listen to the police officers, what he wants, his request, very carefully, because especially it shouldn't matter. You should have the leeway to kind of be loose or whatever, because Caucasians have that, but you don't have that leeway. We don't have it. That's just the reality. We melanated people want to keep living in a false reality that Caucasian, America has painted for you, that, this is America and they're supposed to do this and we're this and, they have to comply with it. Yeah, that's true for most Caucasians. For you, who's melanated, it's a different game for you. And, and that's where we go back to the slave drove. Because, the police officers or, police force was started with the slave patrols. So that mentality doesn't leave, it just gets warped and contorted in certain ways. But if that thing was started like that, the whole organization was never started to bring security to citizens. That wasn't the inception at all. That wasn't the idea. Hey, you know what? Let's make sure that everybody is safe and secure. And no, that wasn't it. Back in them days, you had to have your own gun. When that shit went down, you had to take care of shit yourself. You had to have your own musket and your own damn gunpowder and all the rest of that when some shit went down. Then, if it was big enough, you would have, there would be police brigades and stuff like that. But these were private police forces. But they started all the way back with that slave patrol. It literally started to keep niggas in line when you got off the plantation. So all of that is still there. Excuse me. That mentality is still there. And now it's not, it's just widespread because more, police officers are not just Caucasian anymore, but they've indoctrinated that mentality into every police officer, even if they're melanated. They see niggas as, the scourge of society, or nigga, you're making me look bad, or they see you different from them because they're in the police fraternity now. So that slave patrol mentality ain't never left. So this is what most brothers don't understand. When you start to engage these dudes, that mentality against you is a main staple of all police forces. It's not meant for you. It was meant to control you. The police force was meant to control, not give you justice, not give no melanated person justice. It was meant to keep your ass in line. And then when you got free, it was meant to keep unruly citizens in line by the rich motherfuckers who the industrial people. So they were hiring the ex-slave patrol or patty rollers to help keep crazy ass workers in line. When the workers start talking crazy, like, nigga, I've been working for 7 hours with no break. Shut up, get your ass back in that line. Or I've been working for 4 weeks with no pay. Shut up, get your ass back in that building. That's what that was for. And you know, it just trickles on down to what you see now. Cats who are basically, they're policy enforcers. They're taught to keep everyone in line. They're not taught to keep justice or to institute justice. So if you follow with that mentality, then, you know what I'm saying, you'll be much more ready to deal with these cats when you start thinking that these niggas are here to protect you. That's not what they're here for. They're here to protect rich Caucasians or just rich people in general, the upper class. But even when you melanated, it still don't work like that. So let's see. So the Constitution. Everybody, y'all got a Constitution?
Yeah.
That's gonna be your most important ally when dealing with Popo. Even though most melanated people are 14th Amendment citizens, which is why you get treated like that. You're a second-class citizen. Again, the police force was created for first-class citizens, not second-class citizens. So even though you're 14th Amendment citizens and second-class citizens, equal protection of the laws clause is in the 14th Amendment. So you have that as your remedy. So whatever law is written for Caucasians under the equal protection clause is written for you, right? So what secures you in your rights from police officers, from the government? The 4th, 5th, and 6th Amendments. So this is what you're gonna have to look up. So 4th Amendment. And this is the main thing that most brothers get the language mixed up. When they say, when they get pulled over by the police and they say, well, the Constitution protects me from unlawful searches and seizures. Is that the right language? Does anyone know? You got your Constitution? 4th Amendment.
Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized.
Bam. Now, where did you hear the word unlawful in there anywhere?
No.
That's the very first thing. That's the very first word, though, that people will use when citing the 4th Amendment. That protects me against unlawful searches and seizures. Ain't no word unlawful is in there at all. It says unreasonable, which is a whole different ballgame. And so reasonability falls into the discretion of the person doing the inspecting under the law. It says under normal circumstances that a reasonable person would come to such conclusions. So under the 4th Amendment, there needs to be probable cause before a police officer violates you of your, violates your rights, as far as property, or seizes your property or your person, right? So they have to, there has to be a violation. 4th Amendment, unreasonable searches and seizures. Now, what is unreasonable suspicion? So that's probable cause. So it says, probable cause for unreasonable searches and seizures. You need probable cause for unreasonable searches and seizures. But what is what is reasonable suspicion?
When you have been suspected of doing a crime or breaking the law.
When you have been suspected of doing a crime or breaking the law. Okay. Where did that come from? And what's the difference between reasonable suspicion and probable cause? I'm just saying if you know. I'm not assuming that you know.
Oh, I'm not sure.
Does anyone know the difference between reasonable suspicion and probable cause before we get in depth on it?
Yeah, probable cause is if they see evidence of a crime, and like reasonable suspicion is if they suspect you of a crime.
Wait, what is probable cause it again?
Probable cause is if they see evidence of a crime. It gives them probable cause to.
That's a form of probable cause,
right?
Not necessarily probable cause itself. So we're gonna watch this. So this is a law professor breaking down. So just really quick. So reasonable suspicion comes from the Supreme Court case Terry versus Ohio. And this is going to be the most important case that mute your phone, mute your damn phones, or all that damn noise in the background. So, reasonable suspicion is Terry versus Ohio. That's the Supreme Court case, 1968. 3 brothers, police officers saw 3 brothers casing a store. Saw these niggas rolling around it at least about 10 times. Looking in the windows, whatever. He walks up to him. He asks him, yo, what y'all doing over here? Oh, we ain't doing nothing. We chilling. Hey, mute your phone while I'm talking. Come on, y'all. Seriously. I have to use your phone. So, he walks up to him and he asked him, what y'all doing? Oh, we ain't doing nothing. So he's like, well, y'all, what's your names? They tell him some bull crap. So while he's talking to him, he's talking to one of the dudes. He turned the dude around real fast, forcibly, and then started patting him down and found a gun. So he didn't have any reason to believe that homeboy had a gun. He just suspected him because they saw these dudes walking around. Walking around this building. So I'm just giving you a background because he's going to explain all that. But when the cop forcibly turned him around and found the gun on him, and then he searched the other dude, they found another gun. They said that the stop was illegal because they didn't have any probable cause. So, but I want this professor to give you a better breakdown.
Exist. And
hold up, sorry.
You might have seen this on television about a criminal procedure topic. It relates to something called stop and frisk. You might have seen this on television, in the movies. You might have seen it beside the road as you're driving. You might have been involved with it yourself. At some point, a police officer is talking to someone, and then he says, you're stopping right here. You're not going anywhere. I'm going to insist. And I'm going to check you for weapons. I'm going to pat you, frisk you for weapons. In that setting, there are legal rules that apply to what the officer can do. Those legal rules go back to a famous case called Terry versus Ohio from 1968. So our topic today is going to be the basics of that Terry decision. Let's go and talk about Terry basics. Okay, folks, let's get started. We're going to be talking about the legal framework that applies to stops and frisks. This is a really important moment in criminal procedure. It's the front gate, really. There are lots of things that police officers do that really don't count as criminal procedure. So I drive my car around, I look out the window of the cruiser, I get out and walk around, I'm the cop on the beat, I talk to people, I notice things that are out in the open. None of that is criminal procedure. And the law of criminal procedure really doesn't address any of that. But when a police officer gets suspicious about somebody and says, you stay right there, don't go anywhere. Once you exercise that authority of the state to control somebody's movement, that becomes criminal procedure. That's where the law starts having something to say to the police officer. And similarly, if the officer says, before we talk anymore, I'm going to check you for weapons, and pats the suspect for weapons, again, criminal procedure has something to say about that. So we're going to talk about the legal framework that applies to this entry point, the first interaction between citizen and police.
Y'all get what he just said? What he just meant? Y'all get what he meant? From what he just said, the statement he just made?
Basically, when the officer gives you a command, he's beginning a criminal procedure.
Yes, exactly. As soon as the officer gives you a command, it's criminal procedure. Now he's subject to certain laws under criminal procedure law. Pretty good, brother. Pretty good. All right, going back in.
Counts as criminal procedure. The whole thing starts with Terry versus Ohio from 1968. I want you to picture this like an old black and white movie with stars with fedoras on and trench coats and old cars running around. And it's Cleveland, 1963, on this very intersection at the corner of Euclid and Huron. So that's Huron heading off diagonally to the left and Euclid heading straight up the picture. It's Officer Martin McFadden walking around. Officer McFadden is a 39-year veteran of the force. He's been a detective looking for pickpockets in downtown Cleveland near all the department stores and the men's clothing stores and women's clothing stores and drug stores and so forth. He watches for pickpockets. He's walking along and he notices these guys standing right at the corner of Euclid and Huron. And they're talking to each other, and at first he doesn't notice anything, but then one of them walks down the street, walks down Huron, and starts looking in a particular window. He can't tell whether it's the Diamond Store or United Airlines, but it's up about 400 feet ahead of him, and he says, He walked in and really took a close look in there, walked past it, turned around, walked again back past the store, looked in again, went back to the corner and conferred with his friend. He says, this looks a little weird. And so he kind of goes off into another store and, is watching from inside the store so that they can't see him. And the other guy goes down the street, looks in the same window, goes further, turns around, comes back, looks in the window. Each of them does this like 4 or 5 times. He says, they are casing the joint for a robbery. It's good 1940s movie talk, right? Casing the joint. But at any rate, he thinks they're preparing for a robbery and they're looking, to see what's inside. So he decides something suspicious is going on. Then this third guy, Katz, comes in, Carl Katz. And he starts talking to the first two who were there. Later we learned they are Richard Chilton and John Terry. And so the 3 of them are conferring on the corner. And then Katz goes on around the corner over onto Euclid. But the 2 original guys, Chilton and Terry, stay there. And again, they do a couple of walks past the store. And then they go around the corner and head up the street on Euclid. And they end up stopping at right in front of a men's clothing store called Zucker's, 1200 Euclid. And so Officer McFadden comes out from his hiding place and walks around and finds them. And he walks up to them after another 2 minutes or so of watching them, talk in front of the men's clothing store. And he says, hello, I'm a police officer. What's your name? All 3 of them mumble something, and he says, "Okay, stand in front of the plate glass window there, the display window for the store." And so while they're outside, Officer McFadden says, "Look, you, the guy on the right, there are 3 in a row, 1, 2, 3. And so he says, you, the guy on the right, and he spins him around physically. He just Terry is facing him, but he takes Terry by the shoulders and spins him around. And then he pats the outside of his overcoat and he notices, oh, I just hit something that I think is a gun. I'm going to get that gun. And so he tries to reach in. It's in the left pocket, but it's an inside pocket, and he can't get to it, and it's sort of stuck there. And so he ends up pulling the jacket off of John Terry. And he says, okay, guys, all of you in the store, and keep your hands out of your pockets. So he orders them into the store. They all three walk in. He says, up against the wall there. So they all stand there, and he says, keep your hands up. So they've all got their hands up. And now he goes along, and at this point he can feel in the pocket of John Terry's coat, his overcoat. He finds there's a handgun there. There's a .38 caliber firearm. And then he pats the outer clothing of Chilton, and he feels another gun, and he's able to reach into the outer pocket of the trench coat or the overcoat for Richard Chilton and pulls out another gun. And then he pats down Carl Katz, and he finds no weapons on Katz. He then checks the guns and notices that they're both loaded. He says to the store owners, call the police, bring the paddy wagon down here. These guys are under arrest for...
What do you just call it? Bring the what down here?
Paddy wagon.
Where's that from?
Sound like the 19th century or something.
Paddy wagon is from the slave patrol. Slave patrollers were called paddy rollers, which is paddy roller. Patrol is a combination of the words paddy roller. That's where you get patrol. And so when he said bring the paddy wagon, that goes all the way back to slave patrols. See how these words are the same? The paddy is still the same goddamn thing from the slave patrol, the paddy roller. And this motherfucker just rolled right on with it and said it. And he probably doesn't know that. Or if he does know, he's skipping over that shit really well.
Carrying a concealed weapon, which is illegal at that point under Ohio law. So Officer McFadden has found his suspects and he has made an arrest. What's going to happen now? Well, these suspects are charged with carrying a concealed weapon. The government's going to try to put in the evidence that Officer McFadden found, but the defense says, hold it, you violated the law by searching my clients that way, so you can't bring in that evidence. So there's a motion, a pretrial motion to suppress. The trial judge denies the motion and allows the evidence to come in. There's a conviction of both Terry and Chilton on these charges, and at that point, we've got an appeal to the Supreme Court. What are the arguments of the parties once they get to the Supreme Court? Well, first of all, there's John Terry's argument. It's a good old-fashioned argument. It's the classic doctrine at the time, and it says there are two levels here. At one level, the police aren't doing anything at all that criminal procedure can address. There's no regulation. If we're just talking, looking at something that's in plain view, if I'm not doing something that counts as a search or as a seizure, then I don't have to justify it in any way. There's no real legal regulation that's relevant. On the other hand, once it becomes a search or a seizure, then you got to show probable cause. You got to show some serious reason to believe that wrongdoing has happened. And so John Terry says, we've been doing this for decades and decades in the federal system anyway, and we know what probable cause looks like. And Officer McFadden did not have probable cause. So easy case, we win. This was plainly a search. It was, you're stopped, so it's a seizure, and it's a search because he's touching the bodies, the outer clothing of the suspects, and he doesn't have probable cause to support it. So we've moved from the lowest level of no regulation at all up to that top level of probable cause, and the government can't satisfy its burden up on that top level. So that's Terry's argument. Good old-fashioned doctrine. The state of Ohio wants something that is in between. They say, we're not so happy with just a two-tier requirement. So note, it pays to be creative. If the law is not favoring you, come up with a reason for an innovation, a slight variation on the current law. Not a huge change, but something incremental can win the day in a common law fashion. So Ohio asks for something in between. They say, okay, this isn't nothing. It's true, he's touching them and there's a search going on. But it's also true that this isn't a full search, like empty your pockets and put your hands behind your back and you're under arrest. I mean, at least at first, when he was just saying stay there, this was something less than a full search, something less than a full arrest seizure. And for that reason, we ought to be able to justify it based on something in between, not full-blown probable cause, but that in-between level that we now call reasonable suspicion. Some lesser showing. And that, they say, Officer McFadden had. He had enough to establish reasonable suspicion that some kind of wrongdoing was going on, that they were planning a robbery. The Supreme Court buys it. And they say, yeah, we now believe that there is that intermediate category, and this stop and this frisk was justified based on reasonable suspicion.
Now, going back. So look at this chart. See what it says? Just so y'all can. So level of intrusion and then level of justification. So for a full search, they need probable cause, right? For a frisk, the level of justification is only reasonable suspicion. And then plain view or other non-searches, they don't need anything. If something like if your evidence is out in the open, then that's acquiescence. They don't need anything.
And this frisk was justified based on reasonable suspicion. But reasonable suspicion of what? And here's where the holding gets interesting.
Well, it's not acquiescence, it's more like voluntary consent that you have your stuff out in the open. So it's considered, if you're not hiding anything, if you don't have it under lock and key, the law considers it as voluntary consent, meaning it's open. That's why, like, if someone is on a motorcycle, and you have a duffel bag. If the police pull you over, they can't go in your duffel bag if it's locked. If it's open, they can't. So that's what.
Actually have to have reasonable suspicion on reasonable suspicion. But reasonable suspicion of what? And here's where the holding gets interesting. You actually have to have reasonable suspicion of two different facts. So first of all, you have to have reasonable suspicion that criminal activity may be afoot. That is, this person either has recently committed a crime or is about to commit a crime. I'm not sure of it. I couldn't prove it in court yet. I'm still gathering the evidence, but I have a reasonable suspicion that you're involved in a crime. And separately, I have reasonable suspicion to believe that you're armed and dangerous. So you make those two separate showings. Notice from the court's opinion in part 3, it's talking mostly about that second form of reasonable suspicion. So it says that it's not going to be enough to have an inchoate and unparticularized suspicion or hunch. You got to have some kind of specific reasonable inferences in light of the officer's experience. But in part 5, it's very clear that there are two different showings of probable cause. First, that criminal activity may be afoot, and that the person involved here is armed and dangerous. That's what you need to show to justify this stop and frisk. Let's imagine a different outcome. What if the Supreme Court had ruled otherwise? Can we?
So, just to be clear, because Caucasians will get the Caucasian-y voice and confuse you. Very simply, in order for a police officer to have reasonable suspicion, he just needs to suspect you of a crime and be able to articulate why he suspects you of a crime. Meaning, you ran away from me, or or while he's talking to you, you seem you're a little jittery. You seem, you seem nervous. Seeming nervous can give a police officer reasonable suspicion that you committed a crime, which is why you always want to remain calm when you're talking to him. But you really shouldn't talk to him. But if you have to talk to him, you always remain calm, because your anxiety, your anxiousness can be considered suspicion that you committed a crime. So it's very simple, and this is what the main things that we need to learn is how they're able to interact with you, and or what gives them the right to interact with you, and then what says no, you can't do it, and then how you voluntarily give over certain rights to be able to for them to be able to harass you and engage with you. So very important. Reasonable suspicion can be it can be anything. They can suspect you of a crime, but they have to articulate why they suspect you of a crime and what crime they may suspect you of committing.
Imagine it. Well, first of all, let's think about whether frisks even existed up until the time that the Supreme Court blessed them in 1968 and said frisks are legal and they're okay if they're supported by these two forms of reasonable suspicion. Did frisks exist? It's pretty clear they did. I mean, the newspaper in Cleveland, the Cleveland Plain Dealer, I always love that name, the Cleveland Plain Dealer went to Officer McFadden in 1967 before the case and said, hey, McFadden, what do you think about the Supreme Court considering your case? He says, well, I sure do hope they approve it because frisking is what police officers do. I don't think we can do the job without this. It's just always been a part of what we do as police officers. So it existed in Cleveland, certainly, and you see lots of other newspaper indications that this was just a common part of policing. So the Supreme Court was, for the first time in 1968, ruling on the legality of something that police officers had done for decades and decades, really generations, going back to the start of policing. Why did they wait so late? Probably because the Fourth Amendment did not apply to the states until, 1961, Mapp versus Ohio, and this is 1968, so only 7 years later. So if you think about it, this Fourth Amendment doctrine really had not been relevant to state.
So really quick, give you a background. What are you talking about? Mapp versus Ohio is a Supreme Court case that came out in 61 that said anything found illegally during an illegal search and seizure is not admissible in court. That's all that says. So Mapp versus Ohio, 1961. Anything that's found illegally, anything found on a suspect during an illegal inspection, illegal search and seizure, is not admissible in court, even if it's a gun or drugs or anything. Like they searching you and they don't have no right to search you, and motherfucking and 8 pounds of cocaine fall out. They cannot arrest you. Back then. Now this is 1961. 7 years later, you get Terry versus Ohio that blew Mapp versus Ohio out of the water. That says, no, that's not true. If we have reasonable suspicion now that you committed a crime, then we can do what we need to do. But before that reasonable suspicion thing came out, you know what I'm saying, you could be caught then red-handed, killing somebody there, and unless they stopped you for that crime immediately, unless they specifically stopped you for that crime, you know what I'm saying, and they're inspecting you for that specific thing, then, whatever they found wasn't admissible in court.
Enforcement until, just a few years before this case came out. So I think that's probably the number one reason. May also have something to do with the growing prevalence of handguns and a few other factors. By the way, speaking of prevalence of handguns, think about how complicated the reasonable suspicion standard becomes in a world where you've got you very commonly encounter carrying concealed weapons laws or CCW laws that make it legal to carry a weapon. Now it's very important to distinguish between whether I've got reasonable suspicion of a criminal activity. Carrying the gun can't count there. It's got to be something else that you're doing that's illegal, versus reasonable suspicion to believe that the person has a gun. At any rate,
That's only for Caucasians. Anybody watching this damn class later who comes after that, what he just said, or having legally having a weapon in public is not probable cause or reasonable suspicion to stop you for an inspection. That's absolutely true, unless you're a nigga. If you are melanated, no matter where you are in America, you having that weapon on you, that gun, is going to be reasonable suspicion for them to stop and mess with. Even though it's illegal, it's unconstitutional, and it's against the Supreme Court, they're still going to do it. Just know that no matter what you think and what you say, they're going to do it. Unless, now in some cases they won't do it. Like we're not going to look at this dude this week. We'll watch some of his stuff next week. But you can study his channel, News Now South Carolina. And I put it, in the law video that I made. He's the one who's at the police station, filming the police station, and they're trying to ask him his ID. So he walks around with a gun. When he does a lot of his stuff, he a brother who walks around with a gun. And so, but he knows the law super well, which allows him to be able to, walk with that armor. But unless you know the law like that, you should not be doing that.
Imagine an alternative. Well, Justice Douglas, pictured here on the right in the slide, William O. Douglas, he says, this whole three-tiered innovation that Ohio wants us to do, it's dangerous. It's an innovation. It can be too easily manipulated. I'd rather stick with a nice, good old-fashioned 2 categories that can't be, tinkered around with. Whereas, Chief Justice Warren, pictured here on the left, says, well, this is really just a reasonable response to the real safety needs of the officers. We really can't imagine ruling otherwise because they're gonna do what they have to do to keep themselves physically safe. So it's kind of an accommodation to reality. I think in the end, Justice Douglas was wrong. You've probably heard me say those words before. When Justice Douglas swings for something, he goes for the fences, and when he's right, he's very, very right, and when he's wrong, he's very, very wrong. But in this case, I think he's wrong. I think it's just as easy to manipulate 3 categories as 2. In fact, if the court had not created that 3rd category, I predict that I anticipate that the court would have started expanding what counts for probable cause and would have watered down that standard. At any rate, that's the ruling of the court and the majority opinion from Chief Justice Warren. So we got a couple of application questions now. Now that you know the basics of the holding and the factual background of the case, how does it go forward from that point forward? Well, one big question is the question of categorical frisks. Put it this way: does the judge in the trial court require individualized reasonable suspicion from the officer in every case to show that this particular person had a weapon or was armed and dangerous? Typically, when law enforcement officers are trained, they are trained to look for certain signs of a person being armed. So you would look for, a bulge in the pocket at a place where a holster might be, or a bulge in the, in the waistband where you might keep a gun. But remember, it's not just guns that you could be looking for. You could be looking for knives or other smaller weapons. So it's not always going to be, an obvious, from the outside, from the outer clothing. Another thing that officers are trained to look for is if the officer comes up and the person sort of turns sideways and is trying to shield the view of one side of their body. Maybe there's a gun over on this side, on the side that they're trying to shield from the officer.
So what he's giving you right now is game on how these niggas are able to approach you. And so a lot of the times this stuff will be going on, or they'll use this as an excuse, and then brothers will be like, man, why you fucking with me? Man, you just messing with me. You ain't got no right to be doing this. You ain't got no right. And technically they do, which is why always when a police officer is approaching you under reasonable suspicion, you always immediately ask, are you detaining me? Or am I free to go? Because they'll walk up and start asking you questions right off the bat. And so first thing is, do you suspect, when they ask you what your name is or for your ID, you ask them, do you suspect me of a crime or committing a crime? And which crime do you suspect me of committing? Or they may say, was there a crime recently committed? If I look like the person, what does that person look like? What's their name? So you ask all these questions, but immediately when you asking these questions, or when you finish asking those questions, the first thing you say, are you detaining me or am I free to go? You want to keep asking them, because if you don't, they'll just sit there and talk to you till you spill the beans about something. So it's very important. Once they, once they, you know, once they walk up to you, you have to establish whether they're able to engage with you or not. They're going to do it, and they're going to hope that you acquiesce to it immediately, because most people are scared of the police. Most people are either scared of the police or they respect the police highly, which gives them leeway both ways. You know what I'm saying? You respect the police a lot. You're gonna be behind their back. You're gonna be nice with them and cordial and all this and that. Be buddy buddy. And if you're scared of them, you're not gonna say nothing. You're gonna sit there and chill and not question anything that they do. So they rely on both of those factors when they approach you, either one. A lot of times, those two things fall under the same thing. You respect them and fear them at the same time.
An odd angle once the officer approaches is thought to be one indication that the person might be armed. But could the officer go further than that and say, well, it's not so much that I saw a bulge in the clothing, or I saw a knife handle or a gun handle sticking out of a waistband, or that they were standing at an odd angle. Instead, it's the fact that I'm investigating this person for drug distribution. And drug dealers, we know, very often have guns. And so it's the fact of drug distribution as a category that gives me this reasonable suspicion. In other words, everything in that box, everything in that category counts not only as reasonable suspicion of the crime, but necessarily reasonable suspicion that this person is armed and dangerous. There are a few courts that have been willing to say that. There's something of a mess in the lower courts on this question of whether the crime itself can count in that separate showing of reasonable suspicion that the person is armed and dangerous. One other thing that is very interesting in application of this case is that we're starting to see something more than just the legal requirements being met for individual cases, one case at a time. So sure, you can come into court and the defendant will say, keep that evidence out, Fourth Amendment, and the government will say, yes, but we can use the evidence because reasonable suspicion that a crime's been committed, and second, reasonable suspicion that the person was armed and dangerous. The frisk was limited to the outer clothing, very limited intrusion, therefore middle tier category, we're all good to go. Yes, you can meet the requirements in one case, but what happens when you start looking at the entire pattern of cases and you start noticing, wow, every time a minority citizen of this city walks out, they're getting stopped and frisked. And pretty much everybody who's getting stopped and frisked is a racial minority. Does that create a problem? Could be a legal problem. It's become the basis for litigation in a number of cities. New York City is one example that lasts really over decades. There's a long-standing series of litigation over the pattern of uses of stops and frisks in various places. What's really interesting about these about this litigation in this pattern of the use of stop and frisk is that very often they don't result in an appellate court ruling saying, yes, this is an equal protection violation and you must stop, here's the injunction. It's not so much that, it's that the case settles. The parties agree, look, we'll agree not to go forward, and the government will agree to collect statistics. We'll keep closer track of how these things happen, and we'll post it on the internet, and everybody can analyze this and see how it's working or not working.
No, whoever that is, when the video is working, y'all got to keep y'all phone muted. Please don't unmute the phone when the video. That's when these mics are strong, and so y'all don't hear it. But when the video replays, you can't hear you won't be able to hear anything he's saying. So it's real important, like when I'm talking or when the video is talking, y'all have to keep y'all mics muted.
And it's that data that has been the key to what happens with stop and frisk since then. So a number of different.
So he's just about to get. So what he's saying at the end of this is some fuckery. So I'm about to just break it down. So we're about to move on to probable cause. So all he's saying is, when instead of really doing anything about it, what they're doing is basically getting data. And he's like, the data is going to be able to lead to something in the future once we have enough data on who's actually being profiled and wrongly accused of these, of these atrocities or these, wrongly suspected of crimes or this or that, then once there's enough data, then we'll be able to do something. Now, fuck all that. No, that's not it. So right from the jump, or what you want to understand about the Terry frisk or the Terry stop is what you're able to do, what you can't do. So I'm going to say what we're able to do and what we can't do, and then when we watch the probable cause video, I'm going to come back and ask y'all those questions. So at a Terry stop, which is basically stop and frisk, when a police officer is able to walk up and engage you and inspect you. Basically, it's a police inspection. When they're there to assess whether you've committed a crime or about to commit a crime. So what they're able to do when they walk up to you, they're not able to arrest you. Let's get that straight. Under reasonable suspicion, they cannot arrest you. What is arrest? Does anybody else know what arrest is? The arrest under the law, especially in California, it may be something different, but most of these are uniform, which is why they're called uniform codes. So, but the definition of arrest is the restraint, the actual restraint of the person. So when they just have you there and asking you questions, that's not arrest. When they put handcuffs on you, that immediately becomes arrest. Whether they take you in and book you or not, that makes no difference. The legal definition or the actual definition of arrest is the actual restraint of a person. So once they do that and they've not established that you committed any crime, they violated your constitutional right. It's real simple. But most people don't know the law that simply enough to be able to apply it like that. Even them, they don't know it like that. They don't know that something that simple can get them in that much trouble. But they bank on you not knowing it though. That's the main thing. They bank on you not knowing. And if you think you do know it, meaning if you think you do know it, they're gonna push back with aggression and authority until you push back with them. Like, nah, law, such and such, boom, boom, penal code, in Los Angeles, in LA, it's penal code 833. States no, an arrest means the actual restraint of a person, meaning once you physically restrain me, you have arrested me, which means you have to have probable cause in order to arrest me. So remember, under reasonable suspicion, they cannot arrest you. They cannot put handcuffs on you under reasonable suspicion until they've attained probable cause that you committed a crime, right? These are two different things. Reasonable suspicion allows them to get to probable cause. However, under reasonable suspicion, the only things they're able to do is ask you your name and pat you down for weapons on the outside of your person. That's it. They can't ask you where you going. They can ask you what you doing. Again, none of that. You don't speak. You don't talk. When they start asking you what you doing, you give them my name, and you let them pat you down, and then you say, "Are you detaining me, or am I free to go?" And you don't say nothing else because they count on you giving them the ammunition to get to probable cause. Because remember, they have to articulate what the suspicion is. If they can't articulate what the suspicion is, what you're suspected of committing, what crime you're suspected of committing, you shut the fuck up and ask if you're free to go. Or you ask if you're free to go, and then you shut the fuck up. So that's reasonable suspicion under the Terry stop. Come on, man. Where's that other video? Oh, here it is. So this is probable cause. And a lot of people mix up the two. You definitely do not want to mix up the two. They're very similar, but they're not the same. Very similar, but not the same. And most people, when they get harassed by the police, they're speaking, you don't have probable cause to do this. They don't need probable cause. And this is where everybody goes wrong. We'll give you probable cause. You ain't got no probable cause to do this. You ain't got no probable cause. Well, I don't need that. All I need is reasonable suspicion. Once you start tripping under reasonable suspicion, when I come up and I start engaging you under reasonable suspicion, and you start tripping, start talking, getting an attitude, start acting funny, then that leads to them having probable cause to be able to do whatever the hell now. Then they can start searching your car, all this and that, once you start tripping, which is why it is of the utmost importance that you remain calm, just laid back, like you just took some Ambien or some shit. You remain calm as hell. Don't give them any ammunition.
Hi there, my name's Ron Wright. I'm a law professor here at Wake Forest University School of Law. We're going to be talking today about a criminal procedure doctrine that's called the doctrine of probable cause. And we'll talk about the way that that's defined. In particular, we'll be looking at one historical moment back in 1949, a case called Reelnagas versus United States. And we'll see what that case from the US Supreme Court tells us about how to define probable cause. And then we'll look at what happened after Reelnagas and what state courts do today. So let's go inside and get started talking about probable cause.
And another mistake by most people who learn the law is they go look at a dictionary to learn the law. It is very important that you have a Black's Law dictionary, but the definitions are not the law. Just so we're aware, I tell everybody to get you a Black's Law dictionary, but and to learn the law. And the reason you want to get a 4th edition is because it has the law cases in there that'll lead you to the exact law. The definitions are not the law. The cases that are made from these words is the law. And so this is basically what he's saying right now. Probable cause, even though it may be defined in the law dictionary, that's not what it is under the law. The Supreme Court or courts around the country have defined what probable cause is, and you have to look to those. And what he's talking about, that doctrine, that's called common law, what the court has ruled on already. Common law is just all common law is just what the cases that the court has ruled on already. So they go to look and see what the court has said regarding probable cause in order to come up with the next answer or for the next case.
Okay, folks, let's get started. We're going to talk today about the probable cause standard. Now, probable cause is the legal standard that we use to tell the government how much information it has to have before they're allowed to stop somebody and arrest them, or second, to do a full-blown search of their home or their car or other place, a non-public place, or even to fully search their person. Not just a pat-down frisk, but a full search requires probable cause. Well, what does that mean? We're going to talk today about how you define probable cause. This whole framework's been with us for centuries, and I'm not going to go back through the mists of time and tell you all the different ways we've done this over the centuries, but I do want to focus on 2 different sources of this probable cause definition today. The first is a case from the United States Supreme Court called Reelnagas versus United States. It was published in 1949, and it has become one of the key sources of language that other courts use as they're trying to describe what we need for probable cause. And then the second set of sources I'm going to look to are things that state court judges say today in their appellate opinions as they're evaluating on an ongoing basis whether the police have a good enough reason to stop a car and arrest a person, or whether they have enough information, probable cause, to support a full-blown search. Okay.
Before he gets into that, I want to just give y'all some more quick background on reasonable suspicion, because this is the main thing that why police come to you, because most of the time probable cause is not what's the word I'm looking for? It's not evident. You know, they have to piece things together to get probable cause, whereas reasonable suspicion is just like, this nigga look like he's doing some crazy. Hold up, wait a minute. And so, you know, they can assess from there. Hold on.
Talk full-blown search.
Oh. So under the reasonable suspicion. Now again, the full-blown search, they don't allow the full-blown search until you get to the probable cause. That's when they can basically they can go through anything they want after that point, unless you assert your rights on. So basically it's like if you're in your car and you lock your car, now probable cause is only specific to what the officer may suspect you of committing, what crime you're suspected of committing. So they can't suspect you of what's a good example? Like, so if they're in your car, they can't suspect you of one violation and then convict you or arrest you for another one. You see what I'm saying? Unless they have the probable cause for that specific thing. So it's whatever they're looking for. So like if they get a warrant, like if a police officer gets a warrant, he has to have probable cause to get a warrant. That probable cause has to state what the police officer suspects you of committing, what crime the police suspect you of committing. So once they get that warrant, and so that's what usually will happen. They'll get a warrant at the police, at the traffic stop to search your car. That's what will usually happen. They don't just jump into your car unless it's called exigent circumstances. Under exigent circumstances, that means like if I don't inspect the car right away, the evidence may be destroyed. So that's when they're able to, to bypass a warrant, is when they have something called exigent circumstances. So like the situation is so chaotic and crazy. If I don't do this right now, it may not, we may lose the evidence forever. Otherwise though, if you, whatever they suspect you of, that warrant is for, it's only specific for that. So if they got a warrant, if they got a warrant to inspect your car for drugs, then they can't look for guns specifically. But if they can get a warrant to inspect your car to look for drugs and guns. But if it says just drugs, they can't find guns and they convict you on that. That's what that. So the law is real specific. That's why it's real specific and real intricate, which is why they hope that you don't know the law, because there's so many outs for you. The law leaves you a million outs, but you just need to know those outs, which is why people pay lawyers so much money, because the lawyers know those outs, or they can go find those outs. Whereas you just like, fuck.
Let's talk first about Reelnagas. Reelnagas the facts happened in 1947. It's out in the plains. It's out in Missouri. It's Missouri and Oklahoma. And they've got laws about alcohol in Missouri and Oklahoma. And so in Missouri, it's okay to sell liquor. In Oklahoma, it's not okay to sell liquor. So we say Missouri is wet, Oklahoma is dry. There's a federal law that says you cannot import liquor into a state contrary to the laws of that state. So it is illegal to go across the line, buy liquor in Missouri, and then to import it into Oklahoma for sale over in Oklahoma, where it's illegal to sell liquor. And so there are federal agents out enforcing this law, looking around for people who might be carrying liquor from one place to another. They see this guy, Virgil Reelnagas. The federal agents who were watching are named Malsed and Crean. So Mossad and Crean see this guy, Virgil Reelnagas. They say, wait a minute, I've seen that guy before. I arrested him 5 months ago for transporting liquor. And now that I think about it, I saw him a couple times in the last couple of months. He was in Missouri loading up his car full of liquor. I didn't get to follow him at that time, but boy, it looked like an awful lot of liquor. I didn't think he was going to just drink that while he was in Missouri. So I think he might be buying liquor again and bringing it to Oklahoma. And as they pass they pass each other on the highway, they noticed when they look back, oh, you know what? He just speeded up. He just hit the road, hit the gas, and is trying to get away from us. And his car seems to be swaying a lot, like it's got a lot of extra weight in it. They can see him for quite a while because this is out in the middle of nowhere. We have a Google map of the roads involved here. So this is just, quite open country between Joplin, Missouri and Veneta, Oklahoma. So the agents turn around, they chase him down, they stop him. Ultimately, they find that he does have the liquor in the car. They arrest him. They bring charges for violation of this liquor sales law in the federal courts. And the original court, the trial court, says, well, I don't think they had enough information to stop Virgil Reelnagas. But once they stopped him, they did talk to him enough, and what they learned from him during that conversation ultimately gave them enough that we could call it probable cause. But there is a problem with the original stop. Now, this would be resolved differently today. This is old law back in 1947, and it turns out today we've clarified that you need something called reasonable suspicion to support the stop of a car, and that's something less than probable cause. But at the time, that wasn't so clear. So the judge was saying, at the moment of the stop, they didn't have probable cause. What you need probable cause for is an arrest or for a full-blown search. But at any rate, the question becomes, well, what is enough for probable cause? Did they have enough here? And the U.S. Supreme Court says, yes, they did. U.S. Supreme Court rules in this case that there's enough facts to support the agent's suspicion here so that it was appropriate for them to stop this driver whose car was kind of swaying on the road. The importance of Reelnagas is not so much what happened to this one guy, Virgil Reelnagas, but what the court says along the way about how to define probable cause. And they say several different interesting things here. First of all, they say that we are dealing here not with certainties, but with probabilities, and they're not technical. These are the kinds of facts that ordinary, non-legally trained people might use in their everyday life to make their decisions. So we're not looking for definitions in law books or in statutes. We're looking for the kinds of facts that convince people in ordinary life to make decisions and predictions about what's likely going on and what's about to happen.
So, real quick, because he'll get deep into it in a second, and I don't want y'all to get into that till y'all learn more law. Because remember, law is a language. So, basically, probable cause is just there's many different things that can lead to probable cause, but for the most part, it's just a number of reasonable suspicions that are put together can be probable cause. Or say if I have reasonable suspicion, a certain number of facts that corroborate that suspicion. So say, like, give me an example. If a police officer is following you and you swerve, right? That gives him, so that may, in his mind, you may be drunk. In your car, you could have swerved to keep from hitting a turtle on the street or whatever it is. However, the fact that you swerved gave the police officer probable cause under his suspicion. See, you swerving made him suspect that you were driving, but the actual swerve, so he can be following you suspecting, oh, this motherfucker may be drunk. He can suspect that, and then he has to have something of evidence that corroborates that suspicion. So if you swerve in the street, boom, that gives him a fact that coincides with his suspicion that gives him probable cause. So that's all really probable cause has to be. It has to be your suspicion coupled with a certain fact. Meaning, I can believe that you niggas is high in a car. If I smell something funny in the car, those two things go up and give me probable cause to suspect the car for marijuana. even if it may be you had some, you had some incense in the car, or whatever it is. The fact that I smell something, I may not know what the smell is. I don't have to know what it is, but the fact that I suspect you of being high, and then I smell something, boom, the law puts those together and says, okay, now you have probable cause. So probable cause doesn't necessarily mean that you have to have certain evidence. It can be, remember, again, just a number of suspicions. Like if I'm pulling y'all over, if a police officer pulls you over and you're in the car with your homies, when I walk up to you, you acting nervous, or your homie, your homie's in the car acting nervous. Excuse me, your homie's in the car acting nervous, or if I'm asking, and this is why it's so important to remain silent. They start asking you questions, and then you just start running off at the mouth. Yo, I did this, or we came from here, or something like that. And then they ask, and somebody else says something, and those two things don't add up. Like you say something, and then another dude say something, and then it don't sound like these two things add up correctly. Boom, that gives them probable cause. Like, hold up, y'all stories don't add up. So again, it's just probable cause is just their suspicion confirmed by some physical evidence. It doesn't have to be, actual tangible evidence. It could be, again, your behavior or something like that. But it has to be suspicion backed up by some type of evidence, or something that they believe is evidence. So it's important that you guys know those two. Probable cause, if you can look up certain videos, probable cause versus reasonable suspicion. There's a lot of videos on that. But just for the most part, it's really simple. Reasonable suspicion, suspect you of something. All I need to do is just suspect you of committing a crime, or about to commit a crime. But I have to articulate that. I just can't suspect you and be like, in my mind, that nigga look weird. You look like you about to rob something. I roll over to you and then be like, yo, that can't happen. I have to see you case like the police officer casing a store, or stalking a person, like you're getting ready to rob the person, or when you see the police officer, you run from the police. Running from the police is reasonable suspicion. Walking away from the police is not. See how real intricate it is? If you're driving towards one of those stops, those police check stops, that they check you for, where they check you for being drunk. Now, you have to go through it. Like if you go through it, you are liable to be inspected. But you don't have to go through it. You can see one of those and make a U-turn and turn out. And it's not illegal for you not to go through that thing when they set up a checkpoint. You don't have, it's not required. It's not law that you have to go through those. And it's not illegal for you to turn around. They can't suspect you of a crime because you turned out of that line. Like, so you could have just got a call from somebody and they want you to go pick them up. Or, you know what I'm saying? You can be like, oh, I'm rolling a different way home. Or anything could be the reason for you turning away out of that, out of that line. So they can't just be like, oh, he turned out of the line, he seems suspicious. It doesn't work like that. So very intricate things. The law leaves you many outs. You just have to know what those outs are. But under reasonable suspicion, they can, again, they have to be able to articulate why they suspect you. So so on these last parts, I just want to watch these couple of videos. Now these are police interaction videos. 2 for 10. All right, so these are actual police interaction videos.
Different cities, either because of litigation that forces them to agree to collect the data, or but just because their citizens say, hey, Chicago, listen.
All right, so let's get sorted. All right, let's watch this one. No. So this one,
I used to manage my team with spreadsheets. It was
so this one is actually going to be one of these auditors who does know his rights, and so I want you to watch how he interacts with the police officers when they're doing their thing.
there. And then we switched to Monday.com. Monday.com is a platform to.
And you guys should subscribe to this channel right here, Audit the Audit, and just watch a gang of these videos. He doesn't go too in depth on it, but he does give you a good breakdown. Like he doesn't go too in depth on the law, but he does give you some of the law that they're using. So if they're in another state, and you know, he'll pull up that state's laws to help explain what they're going through.
Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. Today's video features a near-perfect audit from the First Amendment Strike Team. Be sure to check out their channel in the description below and give it the credit that it deserves. Let's dive right in and audit the audit.
Hey there.
On March 31st, 2018, Officer Romero of the Pueblo Police Department in Colorado made contact with Auditor Sean O'Connell as he was taking pictures of the police department building from a public sidewalk.
How are you? Excuse me, sir. What are you doing? Hey. Hey.
All law enforcement officers are trained to conduct 3 distinct types of citizen-officer encounters: consensual encounters, investigatory detentions, and an arrest. Consensual encounters do not require reasonable suspicion or probable cause as long as a reasonable person would feel free to leave or decline to speak with the engaging officer or officers. An investigatory detention, or Terry stop, enables the police to briefly detain a person for further investigation if the officer has reasonable suspicion to believe the person stopped is involved in criminal activity. In order for an officer to place an individual under arrest, probable cause must be acquired. At this point, the interaction taking place between Officer Romero and Mr. O'Connell is considered a consensual contact. Mr. O'Connell is under no legal obligation to engage with the officer and is well within his rights to ignore him. Officer Romero is also acting within his authority by initiating consensual contact with Mr. O'Connell.
I'm asking you a question. Who are you? Why are you taking pictures of the department? Sir.
The moment Officer Romero made physical contact with Mr. O'Connell, the interaction became an illegal investigatory detention. In order for an officer to conduct an investigatory detention, reasonable suspicion of a crime must be present. The First Amendment guarantees all citizens the right to take photos of almost anything which is viewable from a public setting, with few exceptions. The 1967 Supreme Court case of Katz v. United States established the doctrine of reasonable expectation of privacy, which gave individuals the right to privacy in areas where it is reasonable to assume privacy exists, such as a telephone booth or public restroom. It is completely legal to take pictures of any local police station from a public sidewalk. Therefore, Officer Romero had no reasonable suspicion that criminal activity was taking place.
Don't touch me. Okay, I'm gonna put you in cuffs. Okay? You're gonna be put in cuffs. Okay, supervisor's on his way. Okay? I'm asking you questions here.
I can be arrested right now, be put in cuffs for taking pictures of the police department. Don't turn my phone off.
Okay, You're not in control here.
I am, actually. You work for me. I don't work for you.
46, I got one in.
Now, what did we say about arrest? What did I say earlier about arrest?
Anytime you're detained, then that's an arrest.
No. No. Almost. Word wasn't detained. What's the word? It's all you close.
Restricted.
Restrained.
Restrained. So restrained means to be physically held back. That's the definition. So when he slapped them handcuffs on the dude, that became a legal arrest. That became, not lawful, but it became legally an arrest. Remember, those are two different things. Meaning, lawful did he have the right to do it? But legal means it was under legal guidelines.
City over here need a super. You're not in control here.
I am, actually. You work for me. I don't work for you.
46, I got one in custody over here. Need a supervisor.
You're gonna lose your job, buddy. It's illegal detainment. Can you please call a supervisor out here? This is illegal detainment under 16.3.103.
The statute that Mr. O'Connell is referring to is Colorado Revised Statute 16-3-103, which outlines when an officer has the authority to stop a suspect. According to the statute, a peace officer may only stop an individual who he suspects is committing, is about to commit, or has committed a crime.
Okay. Hang on here.
You don't have permission to search me. I don't consent to any searches.
This Friday, don't miss The Gentleman.
These damn commercials suck.
Any search procedures.
Okay, I'm waiting for a supervisor to come up here.
Okay, that's fine.
Okay.
What's your name and badge number?
Romero,
Romero?
0702.
Okay, sounds good. Did you stop my video camera over there?
I'm not messing with your phone. Okay.
Can you tell this officer to take his hands off me and to uncuff me?
I don't want to tell him anything.
Okay.
He'll wait till a supervisor gets here, and you can talk to him from there, okay?
I'm done talking to you guys then.
Okay. He's taking pictures of the department, taking pictures of all our stuff here, so I don't know what he's doing. Try to talk to him. He's not talking to me. He starts walking away.
While the act of public photography is not illegal, it can be considered suspicious. Officers are allowed to make consensual contact with citizens who are photographing in public, but officers cannot conduct an investigatory detention unless they have reasonable suspicion of the occurrence of a crime. Reasonable suspicion must be supported by a collection of objective facts which lead an officer to believe a crime has or is going to be committed. Mr. O'Connell is on a public sidewalk in the middle of the day. There is no obvious evidence of a crime occurring.
Is that a reason to cuff me?
Yeah, you're being detained right now. Yeah.
For what? For what crime?
No, it's reasonable suspicion.
Of what crime?
Okay.
You have to have reasonable suspicion of a crime to detain somebody.
I am not going to speak to you.
That's
You can
fine.
speak to my supervisor when he gets here.
You have me in cuffs right now.
Okay, yeah. You're being detained at the moment. Yeah.
Because you're a
And just to be clear, them having you in cuffs is also a detainment, but it is technically an arrest when they physically restrain you. So you can treat it as that, especially if they've arrested you in violation of your rights. If they've done that and haven't established that you've committed any violation or any crime, then that's illegal.
Probable? Yes, sir. Okay. I'm not asking you questions.
What? You didn't ask me any questions? You asked me what I was doing. I chose not to answer you, which I have a right to do. Do I not? I do. Thank you. I hope this doesn't take long. Hey guys, I'm still live streaming. Call the Pueblo Police Department. Let them know officers Romero and Waring, something like that, are both detaining me illegally outside the Pueblo Department.
It's always on.
No.
Are you kidding me?
Critics everywhere are falling for the gentleman.
Dude, these commercials are ridiculous.
So I'm loading up. I'm loading up. This guy's on the corner. I thought he was taking a picture of the eagle on the department. He's like, oh, okay, no big deal. So I start, putting myself in my patrol vehicle. So he walks past it. And I was like, oh, he's leaving. Give me an answer. Can't talk right now. I'm busy. So he starts walking. So I back up, and then he's up next to this corner now taking pictures. What's he doing?
Officer Romero admits that the only reason he stopped Mr. O'Connell is because he was taking pictures in public. There was no circumstantial evidence produced to establish reasonable suspicion for the officer to conduct an investigatory detention.
So then he comes over, he starts taking pictures. Oh, it looks like he's taking pictures of these signs. I don't know if he's taking pictures of these cars or what. Part of an organization called the First Amendment Strike Team. Is he? Yeah. Okay. So he's trying to see what we're going to do. Okay. He has every right to do that. Okay, and that's fine with that. I don't have.
Did you hear what he just said? He has every right to do that. See, this motherfucker, he knows. The supervisor cop came out and said, because he probably knows that these guys do that, and they're around there checking to see if these police officers know the law. And he came out there and he knew exactly who this dude was. He's part of the First Amendment Strike Team. He can do that.
Tim?
I did nothing wrong. I was not breaking the law. This officer just illegally detained me under CRS 16-103.
I've seen your video, sir. And I know exactly what you're talking about.
Who am I?
First Amendment Strike Team.
Okay.
I know exactly who you are.
Exactly. So you know I'm not out here doing anything illegal.
I do.
No, nothing.
I do.
I like to file a complaint against this officer for deprivation of rights.
You can actually go into the department. Okay.
Overall, Officer Romero gets an F for illegally detaining Mr. O'Connell for refusing to acknowledge him during a consensual encounter and for being ignorant of the protections granted to public photography under the First Amendment. Mr. O'Connell gets an A+ for immediately asking for a supervisor, citing the exact statute which the officer was violating, and remaining silent throughout the majority of his detention.
Now, see, you don't need to, if you know the law, you just state the law. If they start tripping, you be quiet, get somebody there who knows the law. Bam. You don't need to be, man, why you fucking with me? Man, y'all niggas just doing it because I'm black and whoop, 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 and this and that, blah, blah, blah. Yeah, they may be doing all of that. Absolutely. Probably 1,000% they're doing it because you melanated. But still, shut the hell up. That's not gonna do anything. That you arguing with the police officer at a police stop is the same thing. I don't know if you guys watch the NBA. It's the same thing as a player arguing a foul call with the referee after the fact. Does the referee ever, have you seen a referee ever change a call in an NBA game because the player was arguing with him after the fact? That's a question for anybody. Has anybody ever seen that?
When I was watching basketball, I didn't see it.
Never.
But, yeah, but that was eons ago, so I have no idea what they're doing now.
But it never happened. No referee. It doesn't matter, because at that point, when you start arguing with them, the only thing that matters to them is them flexing their authority. That's the only thing that matters. They want to assert their authority. They want you to respect their authority. So no matter what goes on at that point, when you start questioning their authority, that's what becomes the matter. The authority, the questioning of their authority becomes the matter, not were you right or wrong. So that's why it's so important, because you're not going to, again, you can be completely right. Just don't, it doesn't matter. It's not going to do you any good to sit there and holler at that dude. Now, having said that, though, I'll say this. because these police officers do use police discretion. If you start spouting the law, a lot of times they'll change their mind. So unlike a referee, if you're arguing with them, they're not going to do anything. See, like a referee, if you're arguing with them, they're not going to do anything. However, unlike a referee, if you know the law and you start spouting the law and how they're violating the law and they'll be in trouble after the fact, then they'll you know what I'm saying, you can start getting some leeway, because that's what happened to me at UCLA when they hemmed us all up and they had 6 police cars out there. And I started to tell the police officer, first of all, I called for the supervisor, which is the captain. They started tripping. They got us all out there. I said, yeah, let me talk to your supervisor, because I knew none of the other police officers were going to know anything. Waited till the supervisor got there. I started hitting her with all kinds of, you can be sued in your private capacity because of this, because of that. I started hitting her with all kinds of law. She was like, oh, snap, hold up. And there was a warrant. They had me in handcuffs. And there was a warrant in my name. I think I've said this before. There was a warrant in my name, and they let me go. She unlocked the handcuffs, knowing that there was a warrant in my name. She was like, nah, let him go. He know too much law. He know too much. Let this nigga go right. So let me see. There's another one I got to show y'all. Where is it? So this is and I'm going to actually I got it. After I show you this one, I got to show you when it doesn't work. All right. So check this out.
Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers 911 calls, probable cause, and investigatory negligence, and is brought to us by General General's channel. Be sure to check out the description below and give them the credit that they deserve. Let's dive right in and audit the interaction. On November 17th, 2018, realtor Jerry Isham and prospective home buyer Anthony Edwards were viewing a home in the West Prince Hills subdivision in Cincinnati, Ohio. After entering the residence using the lockbox that Mr. Isham had access to, the neighbor across the street, retired Cincinnati police officer Thomas Brannigan, called 911.
The house is for sale, but it's not an open house today. And I just seen 2 male black subjects force the front door open.
After receiving the call, the dispatcher put out a notice for officers to respond to a breaking and entering.
Over B&E 1093 Morado Drive. 2 males forced entry into the front door.
Did you see this? He said they had a key, and he says they forced the door open. That's a blatant lie.
At this time, 1093 Morado Drive, 3221.
Before approaching the residence, officers made contact with Mr. Brannigan to confirm what he had witnessed.
Came up, pulled on the door, pulled backward, jumped under the door, put his shoulder into the door, and opened it. On this 1093.
The officers then attempt to make contact with Mr. Isham and Mr. Edwards.
Where's Ox at? I got movement in there. Address 1093 Morado. Pete, they're right up there by you.
This is the body cam of Officer Rose Valentino. Note that Officer Valentino has already drawn her weapon, although no immediate threat has presented itself, and she has no reason to believe that either Mr. Isham or Mr. Edwards has a weapon or is armed in any way.
But there's 2 report that there's 2 black dudes who broke into the house. That's enough for her to pull her gun. Y'all see what's going on? Laws are not the same. Y'all have to put that in your head immediately when y'all dealing with these niggas. We're not on the same world. We don't deal in the same land as Caucasians when dealing with these popos. You have to have that right off the bat. Because this motherfucker pulled a gun and she didn't even see nobody. All she has is a report that there's 2 brothers.
And the other thing is nobody else out there has their gun unholstered except her.
Except her.
Valentino is the only officer on the scene that ever draws her weapon during this interaction.
What we just said.
He's right up by your window. I'll order him to come out.
Hey guys, come on out. Come out, bro.
Knox! And
Oh, so just so y'all know, that last video that we saw with that guy, he sued those cops and got $41,000. Just so y'all know. So when y'all follow the law and y'all know the law, y'all do it on camera, y'all just remedy, you can get some money. Now, most of these people don't know about the police bond, or they would threaten you. I haven't seen anybody yet on these tapes who actually know about that police bond. That's some hidden information that most people don't know, that they won't let get out there. But you can definitely sue these cats. It takes a minute, but you can get some money. Like, especially when you complied with the law correctly and they haven't, and it's on camera. You sit back and let a lawyer sue the police station or sue the police force, and you'll get some money. Homeboy got $41,000 just for that little shit. Just for taking pictures of the thing, he got 41 grand.
Do it.
Tell your friend to come.
Come around, bro.
Knox!
What you doing?
And
hands up. What y'all doing?
See?
Tell your friend to come out too. Hands up.
Come on now, man. We got an appointment to see this out. That's why you're forcing your way in. That's why we're here. Oh, man, I don't know. They just white people calling the police doing it. I ain't even gonna buy the house. Being a good neighbor, you see somebody going into a house. I ain't gonna buy the house. I ain't even gonna buy it.
How'd you just get in?
Be a realtor.
At this point, officers have been informed that Mr. Isham is a realtor and that he and Mr. Edwards have an appointment to see the house. In the 2014 case of Navarrete v. California, the Supreme Court held that information offered in the form of a tip can be used to support reasonable suspicion and justify an investigatory stop. The court firmly rejected the argument that reasonable cause for an investigative stop can only be based on the officer's personal observation rather than on information supplied by another person. The court favored the reliability of certain citizens and circumstances over others and pointed to factors that could contribute to the authenticity of information offered by 911 callers. The court held that statements about an event made soon after perceiving that event are especially trustworthy because they leave open only a small amount of time for deliberate or conscious misrepresentation. A similar rationale applies to a statement relating to a startling event made while the declaration was under the stress of excitement that it caused. Unsurprisingly, 911 calls that would otherwise be inadmissible hearsay have often been admitted on those grounds. Given that Mr. Brannigan is a retired officer who has received proper police training and is also familiar with the area, it is likely that a court would consider his information more reliable than an average citizen's and declare that Mr. Brannigan's observations justified an investigatory stop.
Turn around. So we can confirm. Turn around. So we can confirm.
Officer Valentino decides to handcuff Mr. Isham until they can confirm the nature of their business on the property, despite already being told why the men were there. Notice that the officers only needed Mr. Brannigan's testimony as justification to suspect Mr. Isham and Mr. Edwards of committing a crime. But Mr. Isham and Mr. Edwards' testimony that they belong there is not enough to dispel the officers' suspicions. The officers are assuming that Mr. Isham and Mr. Edwards are guilty and expect them to prove their innocence rather than responding to a call in an attempt to ascertain what actually happened. I have made a video that discusses the guilty until proven innocent doctrine in more detail, which I will link in the info card above. It is clear that Mr. Brannigan's opinion of what happened here dictated the actions of the officers, and that the officers demonstrated a complete disregard for the alibis of Mr. Isham and Mr. Edwards, ranking the observations of Mr. Brannigan far above the credentials and reasonable explanation offered by Mr. Isham and Mr. Edwards.
Did you use a key? Where's the key at? Where at? a seat.
If we was white, they wouldn't have did this.
If they was white, they wouldn't have did this.
You got some type of realtor ID on you? I don't give a that.
What just happened? Now, what just happened that that the police did that? Well, I'm not gonna say. So what just happened? What did you just see right there? From what we've been learning all day today, what did you just see? What just happened right there?
Do you want me to answer or you want me to stay on mute?
You can answer after somebody else try. I already know you. You've been in this one.
All right.
Give somebody else a try first. Come on.
No legal arrest.
That's an arrest.
Why is it an arrest?
Because he was physically restrained.
Physically restrained him before he had the evidence.
And so, with her doing that, what happened? With the police doing that,
It violated the right.
There you go. How did it violate the right though?
By her actually putting her physical restraint on them without having, I guess, suspected evidence?
What was supposed to happen?
She's supposed to have evidence before she did it.
Right.
Right. But what were the police supposed to do when they came up in there? Under the call that they had.
Ascertain why he was there.
Probable cause?
No. You wait. Say what were you saying? Ascertain what?
Ascertain why they were there and if they had a right to be there.
Right. Under what doctrine?
Terry versus Ohio?
Nope. Well, yeah. That's it. Yep. Terry versus Ohio. Reasonable suspicion. So what happened is they rolled up and immediately placed handcuffs on that dude, which is an arrest, without having any evidence that he committed a crime, just based on hearsay. Mm-hmm. When he offered in a contradictory alibi, when they walked up and they didn't assess whether his alibi was correct or not before placing this nigga in handcuffs. They just assumed this nigga was guilty and arrested him. Which before assessing, before having probable cause. Remember, they're there on reasonable suspicion. They don't have you have to have probable cause to place you in handcuffs. So once they placed him in handcuffs, they violated the law. Good job.
Hey, what's up?
Where's my job? I didn't say what. In your pocket or your car? White or black? Where's my job? I didn't say what. In your pocket or your car? Okay, you want to throw that out, guys.
Until this point, Mr. Isham had been the only one in handcuffs. It wasn't until the officers grew tired of Mr. Edwards' verbal protest that they decide he is enough of a threat and that they have enough evidence to place him into handcuffs.
Where's the, why were you going to jail? Where's it at? Break into the jail. Huh? What? Where's your realtor ID? Where's your, do you have like ID on you? Which pocket, sir? We've got lots of pockets.
Did you hear that dude? He said, take me to jail. I want to go to jail.
Yeah, we would. If you ride along, you know what we do, huh? You know how we do our job, don't you?
Now, what just happened? What just happened? What did that lady do? The lady police officer. Come on, it's an interactive class. Don't clam up.
I missed it.
Y'all didn't see what the lady just did?
I missed it.
Yeah, Joe. It's amazing. It is amazing. Yeah, we would. If you ride along, you know what we do, huh? You know how we do our job, don't you? Sit down here. Every day. This is the everyday shit. Now you search this place. We got drugs and dope.
We got drugs and dope.
I didn't,
Did she have permission to search him?
he's got an ID and he's got realty cards on.
Wait, say it again?
Did she have permission to search him?
You tell me. Under what doctrine? What allows her to search him? What gives her the authority to search a person or any police officer?
Well, I don't know that one.
Yeah, you do.
It's right there under your nose.
I'm telling you, you know.
Because he's arrested.
Well, we're confusing it. So clean it up. Clean it up a little bit. You're almost there. Clean it up just a little bit.
All right. Since he's being detained, she can search him.
No, that's actually the reason. That's actually you have it flipped. If he's only detained, which is what the call that they got, reasonable suspicion, they're not supposed to search him. They're not legally allowed to search him. Go in his pockets.
Right. Okay.
They're only able to pat him down for weapons.
Right. There you go.
Only ask him his name. He doesn't have to show ID either. She went in his pocket asking for ID.
Gotcha. Okay.
So it's very important, this is what I'm saying, that you guys understand what they are allowed and what they are not allowed to do. Right from the jump, if he knew the law, he could have flexed on all of them. First of all, you just this is an illegal arrest, an unlawful arrest, because you just put me in handcuffs without ascertaining if I committed a crime or not. Bam, right off the bat. Then you went in my pocket, which is a violation of my Fourth Amendment right. But he get bam, bam, bam. He could just start hitting him with all kind of law. And if see if he truly knew it, all you need to do is just know where to find it to give you the confidence. It's written there. Once you see it written down, you should have all the damn confidence in the world that law exists. And run it off. No, you violated. No. Boom, boom, and you get at him like that.
See, I didn't know if he gave her permission to go in his pockets.
No, he just standing there. Now, again, once you're handcuffed, it's arrest, and they don't have to have permission when you're under arrest to go in your pockets. But she didn't have the permission. She didn't have the authority to arrest him. See, she assumed it was color of law. It was because she illegally detained him and illegally arrested him. So right off the bat, all these cops done fucked up. Right off they done all fucked up.
Who'd you arrange this with?
Are you the only two in there?
None of your business. Who did you arrange this with?
And you got into the key box?
Yeah.
We got called.
He said, "Don't play the race card. That stuff doesn't play out here." Did you hear that, fool? You're playing a race card. That stuff doesn't play out here. So you would be harassing two Caucasians looking at a house. He would have called the police on two Caucasian dudes walking in the house. Is that what you're telling me? That we called the police on us because we two niggas.
These guys forced entry, which is why. Yeah, and he's got relative cards on.
And really quickly, the dude who called the police on him, which was an ex-police officer, he knew he had to use forced entry in order for them to show up. Meaning he lied. He knew he had to lie because they can't show up if they didn't force entry. You just can't be like, oh yeah, these niggas are standing out. Well, is anybody telling them to get off the property? Is there a trespass sign on the property that they're violating? Is the owner of the property telling them to get up? No, any of that. You can be on somebody's property, even if they don't know you're on their property, or you don't have explicit authority to be on their property if they don't tell you specifically that you have to get off. So for trespassing to occur, there has to be a sign on the property that says no trespassing. Then you violate that. Or the owner has to specifically tell you, you're trespassing, get off my property. Then once you come back on the property after either one of those two things, then you're in violation of trespassing. The officer who called this in knew that these niggas weren't in violation of trespassing because ain't no sign up there. Ain't no sign of it. He knew it was an empty house because he said there's not an open house today. How you know? So that means you knew it's an empty house being sold. So what's in the house that these niggas are trying to steal? They're trying to steal the house? It's an empty house. So right off the bat, that police officer was with the fuckery. Lied and said they had forced entry in order for the police officers to have to come out. And then once he used 2 black guys, you look at how many police officers showed up.
Although Mr. Brannigan's 911 call did offer the officers reasonable suspicion to conduct an investigatory detention, it did not grant the officers the probable cause needed to conduct a search of Mr. Isham's pockets. The doctrine of the Terry frisk grants officers the authority to conduct a pat-down search of individuals they suspect may be armed and dangerous, but the Terry frisk is extremely limited in its scope and only applies to the exterior of an individual. An officer cannot automatically frisk everyone lawfully stopped under the Terry doctrine. In addition to reasonable suspicion that criminal activity is afoot, the officer must also be able to articulate reasonable suspicion that the suspect is armed and dangerous. Officer safety alone will not justify a frisk. The officer must be able to articulate why officer safety was an issue and exactly what risk or danger to the officer or others existed. Officer Valentino began her search by going directly into the pockets of Mr. Isham without probable cause to do so.
Yep.
Don't miss the gentleman.
It's beautiful cinema.
This is ridiculous. I gotta find another place to watch these.
You just have to get the correct app for your computer.
Right.
What happened if it was Windows?
So I have a question. In this case, can he sue or put a judgment on the bond of the police officer?
He could have if he knew how. Most people don't know that. That's the bond doctrine that I teach, man. That is literally no one knows that. No one knows that information. That's like very little. You know, you got some Caucasian sovereign cats who know it, and they've been using it mostly, which is where a lot of this information actually comes from. They were putting a lot of liens on judges' property. They were literally kicking judges out of their home. So because remember when you get a lot of these bonds, you have to put personal property up sometimes, and so that ties to your credit. So when someone places a lien on that bond, that messes up your credit. So a lot of these officials, public officials and judges and stuff, their credit was being messed up behind these bonds. So, you know, the Caucasians were really hitting them with it. And then they came out with a law that says anyone who knowingly places a false lien against a police officer or public official will be in violation of such and such. But the wording on that is knowingly places a false lien. But I'm not knowing the lien is not false, and I'm not knowingly placing a false lien. So that's the doctrine. Excuse me. That's the doctrine on that. But anytime a police officer violates your rights, you can sue them or place a lien on their bond. Most people just try to sue them. He said, I went in the lockbox. He said, whoever saw me going in the lockbox. And if I can get in the lockbox, that means, nigga, I have a right to be here. You don't force yourself inside I don't know if y'all been to open houses before. Y'all know what a lockbox is?
Yeah.
Most of y'all?
Yep.
Yeah, you have to have a code, a combination to get in the lockbox to get the key.
He just didn't want any black neighbors.
Yeah. You have to have I can't force myself into a lockbox, nigga. It's locked. That's the whole point.
Do you have the key to the lockbox on you? Hey, which pocket is it?
I would move in there anyway. He said he didn't want to buy the house now. I would move in there and piss that damn cop off.
What about the little? Should it be like in a little? Well, you can't find it.
Now look, do y'all see how much they searching this dude and haven't established any probable cause?
Mm-hmm.
They are in this nigga right now.
They were only supposed to pat him down. They've been all in the jacket.
Man, they do. So I'm gonna try to skip to the end real quick.
To remove the hand is completed, the Officer Knox instructs Officer Valentino to remove the handcuffs from Mr. Isham and Mr. Edwards.
So again, note, if at any point in time you're placed in handcuffs, a police officer has to have probable cause to place you in handcuffs. Not reasonable suspicion, probable cause. Very important. So circumstantial evidence that you may have or are about to commit a crime. Some type of tangible or evidence needs to be shown for them to place you in handcuffs that you've done something wrong. Now watch how many, they're gonna show how many cops are there. Look at that. You see all them cops? Look at that. Y'all see all them damn cops?
Sorry about that, so we can only go by it's reported to us. Okay? Yeah, I couldn't find it, so.
And she goes sorry about that, and she pulled the gun and pointed at this dude and could have killed him. And she go, oh, sorry about that.
Left inside.
Damn commercial, man. God damn.
To make climate the #1 priority of the American government.
This is ridiculous.
She knew she messed up when she went in and she found the key.
Mm-hmm. Yep.
It was downhill from there because her whole demeanor changed because she got real nice.
Yep.
It is important to note that officers negligently allowed Mr. Brannigan to freely roam the scene instead of securing the location to conduct an investigation. After releasing Mr. Isham and Mr. Edwards, the officers left the scene without making an arrest or investigating further. On July 15, 2019, Mr. Isham and Mr. Edwards filed a lawsuit naming the city of Cincinnati, as well as Officer Valentino, Officer Knox, and Officer Pete. The complaint alleged that the officers violated the Fourth Amendment rights of the two men and that the city failed to properly train its officers on the constitutional rights of individuals. Approximately 3 days after the complaint was filed, the city of Cincinnati agreed to pay Mr. Isham and Mr. Edwards a total of $151,000.
Bam! 3 days. They saw that video, they was like, y'all niggas fucked up. And they saw that video like, nigga, you pointed a gun at this nigga. You basically threatened his life. And he hadn't committed no crime. These niggas can sue us for millions. Yeah, give these niggas 150 after 3 days. They looked at that, and them lawyers came back and said, you know what? They can sue us for millions.
And that's why the cat that was actually in cuffs, when he didn't say anything and he just cooperated, I was like, he's probably been through this before, so he already knows I got a case I'm about to get paid.
Man, paid. And that was the realtor that she was going all in his pocket.
Right. That's why he was so calm.
Mm-hmm. And so, bam. After 3 days, let me tell y'all something. When the police officer settles after 3 days, they know they messed up. They like, oh, snap. I wouldn't have settled for the 151. They could have got like at least 10. They could have got 10. That woman pointed a gun at him. It could have, and all man, she pointed a gun and was ready to shoot this nigga without having any evidence that he committed a crime. Any. And even without any investigation or whatsoever. Oh man, they shouldn't have settled, but they probably just didn't want the hassle. But I wanted to wait till the end of this to show y'all. You have remedies, man. If y'all know the law and you comply and let them do all the messing up, you can get your shit back. You can, man, there's so many remedies for you. Now, for me, what I would have done, first I would have filed the lien on their bond, so they can't work. And then I would have filed the lawsuit on them. So now while you waiting for this lawsuit to smash down on you, nigga, you can't work. I'm double hitting your ass. That's how you do it. Because usually when you file a lawsuit on them, it takes at least a year to 2 years before you get your money. So they working that whole time and getting paid. So they don't really feel the hit. And then when they do, when you do get paid, it's the city. You know, they feel their bond insurance and all that stuff goes up, you know, when they got to pay out like that. But still, the only way to make these niggas feel it is to hit their bond immediately. And then watch these niggas sitting at home, watch Netflix. while they waiting to be sued, while you waiting to take their house from them. That's the main way to get down. So I'm gonna cut this off at 3 hours because we're gonna be doing these. So next week we'll get into excuse me, we'll get into more traffic stops. These are more police stops. We'll get deeper into traffic stops and more of the case law that you guys should know. If y'all, so remember, you go to Audit the Audit. He has a gang of videos on there. There's no playlist, so you just got to search through the playlist to find the videos. But next week, we're going to go over like some of the most common charges they use against you to, you know, and basically bogus charges like disorderly conduct or resisting arrest or, excuse me, you know, what is it? Sometimes they'll get you for cursing at a police officer, or, you know, all these different things that, you know, these bullshit laws that they'll make up. So we'll go over a lot of those. And they're not necessarily made up. What they do is they'll take an existing statute and extend it and basically falsely apply it to what you're doing. And then when they get into the report, they'll rearrange the situation to make it seem like you were doing what they filed the charge against you for. So it's very important. Oh, that was the other thing. Man, that was the first thing I was about to talk about. So the very first thing that you guys, or that you need to do at a police stop, just because we'll go over police procedures and stuff that you should do next week. But this is something that you can get now. All of you, every single one of y'all need to get a dash cam. And this is what I'm going to be pushing for the longest. Every melanated person needs, like I mean, it's imperative. It's life and death. All of you should have a dash cam. Not your phone, not a little thing that where you can put your phone in. That's cool too, but you want a dash cam. You can get them on Amazon for $29. That's the cheapest. And they're from like 29 to, you know, some of them are, you know, about $100. But a dash cam that you can stick on your thing and it swivels. The thing swivels around. So no matter what, it happens. So when you're driving, you can have it swivel, turn towards the road. You should always have that anyway, just in case somebody hit your car or shit. You know, everybody needs one of those nowadays. But you should always have it moving because it shows what you were doing when a police officer was getting ready to pull you over. So a lot of times they lie right off the bat. You ran this stop sign and you did this and you did that. That's why you need to have that dash cam rolling when you're in your car at all times, because it's recording if you violated a law or not. Because that's usually what they'll hit you with, a lie all the time. You ran this stop sign, or you did this, or you cross the walk, whatever it is, they'll always lie. And then you don't know because you were moving too fast. You have no idea whether you committed that or not. And most people don't ever fight that because they don't know. They'll go to court and you have no idea. Some people will go and fight and say, oh, well, and say, let me see the footage. Let me see the dash cam footage. But most of the time they don't. That's why it's important for you to do that. But also you can, when that dash cam is there, they tell you to put your phone down. When they pull you out of the car to assess the situation, if it's reasonable suspicion, they can't tell you to put your phone down. But once they get ready to arrest you and throw you in handcuffs or something like that, they have probable cause, and then the probable cause it boosts up. So now they're doing way more at the situation to search to effectuate a search and seizure. You need to have that cam going because then they can take your phone when they're doing a search and seizure and they have you detained physically in handcuffs. They can take your phone while they're doing that. So it's important that you have that dash cam on if they pull you out of the car and swivel it towards the outside. You don't want to have that phone on the little thing down and on your dash thing. You want to have it up above on that on that dash where everything can be seen. You can swivel and turn it around. That is the utmost important. It's not even important. It's a law. You have to have it. You have to have that. Because if you don't, all the rest of the shit is gonna be out of play. It's like, so say if you have a constitutional rights card and you gave that police officer your constitutional rights card that explains everything about the law, and you want to remain silent, but everything you want to tell that police officer is on that card. If you don't have the dash cam going, he can take that card and throw it away and say you never gave him anything. He can rip it up, you can burn it, take a lighter to it, whatever. If you don't have a dash cam going, there's no evidence that you gave him that card. So it's of the utmost importance still, especially when you start to know the law. You want to document all of this shit. But when you go into court and you have and look for your remedy. So if y'all don't have dash cams and y'all driving, get a dash cam today, tomorrow, $29. Just saw one today, $29 on Amazon. Swivel dash cam, no money. It definitely that's no money to pay for your safety. Save your ass. So let me see. Anything else I need to go over to do? Oh, so laws that you want to the law classes. I mean, not the law class, the law cases. Make sure you go and read up on Terry versus Ohio. Let me see. Here's some other ones. Where's the law cases at? Hold on. It's got to be it. All right. So some of these law cases that y'all want to get into. So, making the police stop. So this is all in the Know Your Rights manual. If you guys get the Know Your Rights manual, you can find this information in there. So Terry versus Ohio. And you can look up all this stuff on findlaw.com. You can it's free law cases all the way around. Findlaw.com or Cornell Law, but FindLaw is better. So Terry versus Ohio, you can look that. You can just put that in. You can find it anywhere. Brown versus Texas.
What was that last one? I didn't hear you on that last one.
Brown versus Texas. And this one is Highbell with 2 I's, Hiibel versus 6th Judicial District Court of Nevada. Let me give you one other one good one from there. So we'll go over some more of these when y'all next week, but I'm just giving y'all some just to study until we come back. Look up Brendlin versus California. Was it Brendlin, Brendlin versus California. So here we go. Where's the reasonable suspicion though? Oh, that's too early right there. Oh. Where's the one? There's another one under here that's actually one of the main ones. I can't find it. Yeah, where is it? Oh, Miranda rights. Miranda versus Arizona. So, here it is. Probable cause. This is the one the professor was talking about. Reelnagas versus the United States. Reelnagas is Brinegar versus the United States. So we're not gonna give you all these. So I just want y'all to look that stuff up right now and get used to reading the law, because reading the law is how you learn law language. That's how you program your mind to understand the law. So look those up for right now, especially the Miranda rights one, because most people think the police have to read you your rights every time they take you in when they arrest you, and they don't. That's not actually. They don't necessarily have to read you your rights every time they take you in for an arrest. So very important that you know when they have to and when they don't, because when they do have to read you your rights and they take you in and don't, that's an illegal arrest, and you're free to go. They have to let you go. If they don't read you your rights in a situation where they had to read you your rights, they have to let you go. So very important to know when they have to do it and when they don't have to do it.
I'm sorry, Kev, but one more time. It was the Brown versus, I didn't hear that last part.
Brown versus Texas.
Texas, okay. Thank you.
Okay. Now, just as a refresher, the higher standard is probable cause, correct? Reasonable suspicion
is the lower standard. Yes,
is a lower standard than probable cause.
Okay. Yes. Reasonable suspicion, they just only need to suspect you of a crime, about to commit a crime, or have committed a crime, and they need to be able to articulate why they suspect that. Meaning, nigga, you was looking shaky. You like you was getting ready to run, or not that you were getting ready to run, but that you ran, or you know what I'm saying, you're nervous. Or when I ask you some questions, your answers didn't match up, or any stuff like that, where they can be like, oh, and then again, that's only under that they're only able to ask you your name and pat you down for weapons. Just to ask, so they ask, and they can also question you again, like where you going, what you're doing, and stuff like that. But that's basically to ascertain whether you're about to commit or have committed that crime. But other than that, you don't got to tell them nothing. You don't have to hand them an ID under reasonable suspicion. If they tell you that you have to hand them ID, you have to assert. You have to be forceful and say, and when you're saying no, I don't. This is not a stop and ID state, and know if you're in a stop and ID state or not, because What that means is even if they have reasonable suspicion, they have to have probable cause in order to get your ID, and they have and it has to be under probable cause. In a stop and identify, well, excuse me, in states where they don't have a stop and identify, you have to have committed a crime for them or some type of legal violation for them to be able to take your ID. Now in stop and identify states, they don't. They can when under reasonable suspicion in a stop and identify state. Now this is where it gets tricky. Some of the law, so the Supreme Court law is what it is. You can use that, but some statutes give leeway into when they can ask you for an ID, which is what they call those stop and identify states. There are statutes that kind of try to circumvent or give certain aspects of when they can ask you for your ID when they stop you. It takes into account this Terry versus Ohio, but then it says, okay, Terry versus Ohio says this, but in this case, we can ask for this ID. In this case, we can ask for this ID. So you should know if you're in a stop and identify state or not. California is not one, so I don't need to worry about that. There's not that many. Most states aren't stop and identify states. Let's see.
You say most states are?
Huh?
You
No,
said most states are?
They are not.
Okay.
But some states are. Like I think I'm not sure. I think maybe Arizona might be a stop and identify state. But there are a few on the board where they stop you. You have to identify yourself. I think New York is one, which is how they were able to do that stop and frisk thing. But again, know your state laws. This is all about knowing the laws of your state, and also not state laws, municipal laws. So really quick, how y'all find that? That's the other thing I was supposed to tell y'all. So before we go, how you find your state laws? You type in your government codes, or you can go to Google and type in state statutes or government state, or whatever your state is, like Georgia state statutes or Georgia state codes. And there's usually a government website that has all of that information, a statute website, excuse me, a law website that they give you all that. So like for California, it's the legislative, it's the website for the legislature for California. And then you can go and find all that stuff in California. In most places, it'll just be your government codes in one website. And so what you do is, for most police codes, they're penal codes, but you may have some of the codes may be under revised statutes, revised criminal statutes or something like that. But most of the time, what you want to do is just go in the search bar when you get to that, and type in police conduct. So that'll bring up the laws that police police are bound to follow. Or if you can't find that website, just do it in Google. You'll say police conduct statutes, Maryland, police conduct statutes, Arizona, whatever, and that should pull it up. And you'll start to see in those, and they're really simple. Like when you start to read those things, like that law that I told y'all about, it's one quick little law. Let me see if I can find it. It's one quick ass little law. That's it. But then it's like one quick little law that, and it's a powerful law, but you know what I'm saying, most people don't research this shit enough to be able to go find it. And that's that actual arrest is or the legal definition of arrest is when the person is restrained, when you actually restrain a person, and that's legal jargon. Actually restraining means to be physically restrained. Because when they're detaining you, it's a different. They may just be detaining you by just a verbal detention. They know you're not free to go. But that's not an arrest. It's just a verbal detention. No, you're not free to go until we assess what's going on here. That's a detention. Handcuffs, bam, and then you got them. When they throw you in handcuffs, they have to have probable cause for handcuffs. And so it's up to you to know if they have that probable cause or not. Because they damn sure ain't gonna tell you shit.
Got that right.
Where is that damn barcode? Hold on, let me show you. Let me find it. Frazier versus damn. So there's a whole lot. So there's so much shit. So yeah, we're gonna be holding these over some weeks. So next week I'll give y'all some more stuff.
Hey man, I got a question. If something has happened in the past, can you go back and get a judgment on that, or
not if the statute of limitations is run out?
Depends on the statute of limitations and whether or not that's run out or not. If it has, then you just out of luck. If it hasn't, then yeah, you can do that.
Is there what's the statute of limitations on improper arrest?
Wait, say that again.
Like as far as like a police officer giving an improper arrest, what is the statute of limitations on that?
Depends on your state.
Okay.
Yeah, that depends on your state. So in California, like if you so say if I wanted to sue somebody or file a lien, if I wanted to file a lien on a police officer's bond, that's 180 days. Some places it could be 100 days. Some places it could be 2 years. So it's just really different. You got to find which one. That's why law is going to be very specific to you in your state. And then it's very important though, if you're going to be traveling and doing shit in another state, you should know them. You should know the laws of the shit that you're gonna be doing. Like if I'm gonna be driving, I should know some of those laws. Like Sandra Bland, if she's gonna be driving, she drove to Texas. So from wherever her state was, if you're gonna be driving cross country like that, then you need to know the laws of the states that you're gonna be driving through and to, just in case. Damn, I couldn't find that damn web. What's it? Damn, man, I was looking for that damn case. I'll find it and show it next week.
Hey, Kevin.
Mm-hmm.
Why is it that a lot of lawyers, and more particularly Black lawyers, aren't using this information to help, liberate the people or give the people the common folk remedy?
What do you mean?
The lien, placing a lien on a bond.
They don't.
Officer's bond.
Most people don't know it.
Okay.
Yeah, most people don't know about the bond lien thing. That's some hidden stuff. Like you had to, and again, these Caucasian, these prepper militia not even militia, just sovereign, these sovereign dudes, and Caucasian sovereign cats. These niggas be on the law, like you've never seen them niggas study the law. Like it ain't nothing. Like you can't like that dude, them dudes who be doing the audits and stuff like that. Those police audits, they be them sovereign cats who be doing that stuff. That's why. So that's they ain't scared. They walk right up to the cop like, "Yo, what's happening? You don't know this law. You don't know that law. You don't know that law. You don't know that." They don't. They do not care.
Plus, they're officers of the court, so the lawyers. So that would kind of contradict that.
Well, no, it's not necessarily. I mean, lawyers were like Johnny Cochran. Johnny Cochran. He was an officer of the court, but he worked for the people. So usually, that only matters if you're trying to be a part of the system, of their system. Does that, I'm an officer of the court thing. Like if you're really trying to be a part of the system, then yeah. But like for Johnny Cochran was really working for niggas. He didn't give a shit about that. That's how he got homeboy $9 million from in New York.
How about Lil Boosie's lawyer? They said he was pretty solid.
I don't know nothing about Lil Boosie. What happened? I don't know nothing about that. I don't even know.
I don't know too much about his case, but I just heard that. Well, I mean, I can't even go off that. That's pretty much what he said. He was a solid guy. I have to do my research though.
Oh, yeah, I don't know nothing about. I don't even know. I couldn't even tell you what Lil Boosie looked like, nigga. if you showed him to me,
I was just gonna say, who is this Lil Boosie that you speak of?
I have no idea.
I mean, I think he's a rapper. I mean,
okay.
About it now, but I mean, I know that's what he's going by at the time.
Okay.
I'm old school, baby. I don't know nothing about these.
That explains why I didn't know anything about it then.
But
he went to jail for a little while, so maybe his lawyer wasn't that good.
Oh, okay. But it's funny. There's not many melanated lawyers. There's only in the video. I think I broke down how there's only 4% of the lawyers in America, or 4% of the lawyers in America are brothers. That's it. 4%. That's nothing. That's literally zero, damn near. So most melanated people who become lawyers, they're trying to get the bag. So they ain't worried about. They don't become lawyers to help niggas. Constitutional rights. They get in there so they can make that money. And they do entertainment law and all kind of other types.
True.
Hey, Roger has a pretty good question in the chat.
Mm-hmm. What's the question?
It says, is the bond specific to domestic cops only, or would it apply to federal officers as well?
You said, would the bond apply to? I'm sorry. Say that one more time. Would the bond apply to who?
Federal officers as well.
Everybody gotta be bonded. Everybody who holds a governmental position gotta be bonded, or they're under some type of bond. Because the government can't have that person fuck up and then you come and sue the government for $100 million. And the government ain't got no firewall. That bond is the firewall for the government. So in case you mess up, yeah, we got to pay, but that bond pays. The bond is, and then either you're fired or the person who did the violation, they're either fired or, they're demoted or, what I'm saying, their bond price goes way the hell up. They got to start paying all kind of crazy money every month for their new bond. Or, all this stuff happens when that shit goes down. Their lives get fucked up behind it. Believe it. That's why I say don't just go in maliciously trying to mess up a police officer, because it really does mess up their life. So make sure that they really tow you up before you go after their bond.
And I imagine that depending on what level you're at, the bond will probably be a different price. It's probably different for local police than state police, possibly.
Always going to be different.
And then federal, like Fed, CIA, NSA, all that.
It's like life insurance. Everybody don't have the same life insurance. Everybody premiums are different. Everybody got different coverage. All of that. Same thing. That's all it is insurance. And so police insurance. And so depending on what you want to be covered by and what you don't want to be covered by, if you you mistakenly injure a person, the bond can cover that. Or if not, then you just hope you don't shoot nobody accidentally. It's like, nigga, let me just wing it and hope I don't kill nobody accidentally, or whatever it is. You just hope if you don't get it covered, you hope you don't commit that violation.
And
so is that anything else?
Yeah, the ATA video with the cat that was at the police joint is also important to know. One of the ways I kind of look at it is knowing what tier you're in, tier 1, 2, or 3 with the police.
Say that again?
Which tier you're in with the police, tier 1, 2, or 3. Tier 1 is just regular conversation. You don't have to talk to them. You can if you want to, but you don't have to.
Right.
Tier 2 is when they're doing their interview, where they're trying to figure out whether a crime is about to occur, is in the process of occurring, or has already occurred. And then tier 3 is when they put the handcuffs on you and you're under arrest, pretty much. Or it could get worse where they're drawing guns and all that. So, yeah.
That's a good way to break it down. Whatever you need to do to remember what you need to remember, man, use that. That's what memory programs are like. They use association for memory. So whatever you associate with that'll help you remember the information better, use that.
Yeah. Also, Roger has a follow-up question to the bond question that says, but in terms of prosecution, how would that work? Because aren't they prosecuted? Well, aren't they protected unless it's taken to the Supreme Court?
Isn't who protected? No. A bond is personal. That's why you go after their bond. The bond is individual, personal to them.
Right.
That's why they have something called a veil, a government veil, or what's the government called? There's a technical name for the government, but it's that veil. They have a government veil where they're not liable. They have a veil where everything that they do is the government takes the hit for it. And that's called the veil. Now, beyond that veil, that's when you see a police officer get sued and the city has to pay. Now, beyond that veil, they have the bond. So a lot of the money, when a police officer when the city has to pay out a major payment, a lot of that money comes from the bond of the police officer. If not most of it comes from the bond of the police officer. They don't pay it, which is why you have to have it. They're not gonna sit there and let you roll around the city all day, harassing and harassing people and doing crazy ass shit, and then the city be liable for it, or the state be liable for it. Hey, wow, they ain't doing that. They like, nigga, we don't know what you be out here doing, nigga, with this badge and gun. You can be doing all kinds. You can have 10 Cambodian women locked up in your basement, nigga, making t-shirts. Who knows what the hell these niggas is doing? We ain't gonna be liable for that. So that bond covers all that.
Good question, though. Roger.
Any other bond questions? Nope. All right, so we're gonna get into more of the the different procedures that you need to know at the police stop. Like, when you're dealing with just police stop law, all you need to know is just the more pertinent stuff, that you will get hit with at that stop. You don't need to know everything about the law. Now, I'll say this. This law is secondary to statutory law. Statutory law is your biggest bulletproof vest that you'll have. But this works a lot too, because most of these police officers, or the system, knows this really well. And so being able to push this, you'll be able to push this through faster and easier than you will status law. However, status law is the ultimate be all. So, like, I'll give you an example. if they arrest you or if they violate, they violate you, they hem you up for a violation, some type of violation, you know, whatever it is, speeding or whatever it is. Even if they arrest you and you make bail, and then you have to go back to court. If your status is changed, that court has no jurisdiction over you. So you can send in something called a special appearance to alert the court they don't have jurisdiction over you. And when you challenge a court's jurisdiction, the court has to prove jurisdiction before it can move forward, no matter what. No matter what you did, if you challenge the jurisdiction of the court, it has to prove that it has jurisdiction first before it does anything else. So even at a police stop, if I was, before they took me into, if I'm at a police stop and I got my status changed and I don't want them to take me to jail, this is in California though, you can ask to see a magistrate, right? Magistrate is a temporary judge or a part-time judge. You go see a magistrate and you ask for a continuance. Usually the judge will give you a 4 days to a couple of weeks continuance so you can present your case. When you do that, you submit a special appearance challenging the jurisdiction of the court. Once you do that, the court has to prove jurisdiction over you before they can move. And then the court nothing else happens after that because there's no way they can prove jurisdiction if your status is changed correctly. That wipes it away right off the bat. Nothing else. Nothing else you have to do. You send that paperwork, you send it, you don't walk in with a special appearance. See, this is the thing. Most people would walk into that court date with a special appearance, but you can do that if you know how to argue your case. You know, if you're articulate enough to argue that case in court, then by all means, you can do that. But you should never walk into court. Ever, ever, ever. There's laws that state you don't have to walk into court in order to actually be in court. So I don't know why people would walk physically in the court and deliver yourself to the enemy. That makes no sense. So under the status change, you would be able to do that. Special appearance is you coming to court. You don't have to physically come to court, but my paperwork is in court for me. And it says that you don't have jurisdiction over me. Now prove it before we do anything else. And they can't prove it because jurisdiction is made by contract. So once you severed all those contracts, they have no proof that you have a contract or obligated to do anything that they say. So I'm getting hungry as hell. So any last couple questions before we bounce? So before I get my food.
I think that might do it.
Yeah, I'm good. I got to do more research now.
Man, so next week, make sure we here next week and put out another bulletin for people to be in. Try to drop in. Try to get this. See if I can get this past YouTube and put on and upload it because we showed a couple of CBS News clips, so they may try to hit us for those. If not, I'll figure out a way around it. I just have to cut those clips out and then piece it up again.
Same more time, same more channel.
Yep. So Sundays at 11 a.m. unless I may have something to do and I cancel it. But Sundays at 11 a.m. we'll be doing these because it's important. Y'all not just gonna get the law in 1 or 2 classes. You have to. It's repeated. You have to. Again, it's a language. So the more you hear it, and the more you're exposed to it, you'll start to develop the synapses to be able to understand it.
All right.
All right. We good?
All minds clear?
For she's.
All right. Let's break.
All right, y'all.
All right.
Y'all, probable cause, reasonable suspicion. If there's anything that y'all learn and commit to your DNA, it's those 2 things because that's what the police officers use to attack you. To harass you and do everything else. For sure, y'all.
Yep.
That's what they use to attack you. So you have to get that down. That is the one thing, if it's anything in the law, that you should master. Is probable cause and reasonable suspicion. All right, y'all. About to grab me some food. I'll let y'all in a minute.
Appreciate you.
Appreciate
it, Kev.
Ghost.
I'll let y'all in a minute.